welcome you back to the second day of our conference. I believe that you have the first day with a lot of exciting data, information, and knowledge about life sentence in various countries through multiple presentation and sharing. And now we continue with session 4, 5, 6, the general discussion and the closing session in this afternoon. Sorry, it's actually in our next 4 hours. And the conference today focuses on 3 themes: the treatment of life sentence inmates, the right to be released, and the life sentence reform in Asia. There is no new technical instruction relating to join a virtual meeting on Zoom because the instructions were given to you yesterday. We just repeat a small but important detail to all speakers. You should speak no longer than 10 minutes in total, though we do know that it is not easy to follow because you all want to share your view comprehensively, sufficiently. And before giving the floor to the chairperson of the third session, we'd like to thank all speakers and audiences for being here with us and wish you good health and happiness. So now is the room for the third session, the treatment of life sentence inmates. Dr. Laffington, my dear colleagues at VNU School of Law, will be the chairperson. Dr. Tung, welcome you, and you have the floor, please.
Oh, thank you, Lanchi, very much. Welcome all of you to join our fourth session on the treatment of life sentence prisoners in Asia. In this session, we will discuss on the topic how the state are trying to balance things between the two important tasks of maintaining the public security, maintaining public orders, while protecting, upholding human rights, especially the life sentence prisoners. In these sessions, we have only 3 papers, 2 from Vietnam and 1 from India. The first one is the right to have a prisoner serving life imprisonment in international law and comparative to Vietnamese law by Ms. Bhatti from Vietnam National University, Hanoi. The second paper is on renovating treatment of life sentence prisoners to meet the requirement of justice reform in Vietnam today by 2 authors from the Commission for Internal Affairs under the Communist Party of Vietnam, Dr. Trương Thị Hồng Hà and Ms. Đinh Kiều Trang. And in the third paper, effects of life imprisonment and the crisis of prisoners' health by Ms. Kriti Khachi from Rajasthan state in India. So we could see, at least here, we could listen to 2 papers by focusing on the right to health. I'm very eager to listen to the papers. So firstly, I would like to invite Ms. Bhatti from Vietnam National University, Hanoi, Vietnam, please, with the paper entitled Right to Have a Prisoner Serving Life Imprisonment in International Law and Vietnamese Law.
Good morning, experts and participants to the session this afternoon. Now I'd like to make a presentation on the right to have prisoners serving life imprisonment in international law and comparative to Vietnamese law. Regarding the outline of this presentation, it includes 5 main parts. First, introduction to my research. Second, the theoretical basis for ensuring the health of prisoners serving life imprisonment. Thirdly, provision of international law and Vietnamese law on healthcare for prisoners serving life imprisonment. Fourthly, comparisons of Vietnamese law and international standards for healthcare of prisoners serving life imprisonment, and finally, conclusions. So in the first part, I will give a concept of the common characteristics of life imprisonment. However, you know, it has been mentioned by a lot of speakers already, so I'd like to skip this part. So you know that the prison environment is judged to be harmful to the health of detainees, and I like a quote from WHO very much. That is, diseases develop strongly in the environment of poverty, conflicts, and discrimination, and prisons is clear evidence of it. And you know, prisoners serving life sentences, although they do not have freedom, they should be entitled to the rights of any human. That's why the government should ensure the health care for such prisoners. Sorry, it's the second part of my presentation. On the theoretical basis for ensuring the health of prisoners serving life imprisonment. So I have 2 points in this part. First, overview of life imprisonment in the world and in Vietnam. And secondly, why is it necessary to ensure the health of lifers? So in the first point, I will introduce to life imprisonment in countries around the world and Vietnam. However, I know that the other speakers already discussed about this issue in the sessions yesterday, so I will skip this point. In Vietnam, healthcare for in Vietnam, the life imprisonment is regulated in the Penal Code 2015. And in this part of my study, I discuss about the characteristics of life imprisonment in Vietnam. Now, regarding the second point, why is it necessary to ensure the health of lifers? You can see on the screen some reasons. I will not go into details of each reasons. However, I will explain briefly. You know, lifers, as you know, normally they commit very serious crimes. That's why it is even more important to ensure their health, because they get a lot of big pressure caused by the crimes. In addition, they also have to live in prisons much longer than the other offenders who commit other type of crimes, non-serious crimes. Moreover, violence in prison is the main cause, which promotes us to do more to protect the health of lifers. They normally stay in maybe small space, or they have to live in crowded rooms, and the quality of life is not ensured in prison. That's why they have a lot of stress. And in addition, as you know, in the world, there are 2 types of life imprisonments, with and without parole. And the guarantee of health for lifers is a must, because after they stay in prisons for 25 or 30 years in prisons, they will get back to the community. And if their health is not good enough during their stay in prison, when they're back to the community, they become sick people, sick persons, and again, they may commit some other crimes. In Vietnam, we have a proverb saying that if you're hungry, you will steal food from others. If you are poor, you will steal other things from others. It means when people fall into difficult situations, they would dare do bad things. They will not mind doing any bad things. So ensuring the health of lifers is also a way to prevent the future crimes in the community. Now I go to the third part, international and Vietnamese law regarding healthcare for prisoners serving life imprisonment. So we all know that healthcare for lifers is an obligation of the government. At the same time, in the context of globalization, when any country wants to integrate internationally, they will have to comply with international regulations or conventions. On the other hand, life imprisonment is a very strict penalty just after the death penalty. However, the healthcare for lifers has not been paid a lot of attention. That's why lifers just get the same treatment as other type of prisoners. And in Vietnam, lifers or non-lifers are kept in the same prison. For example, in some prisons in Bình Phước province, in Thái Nguyên province, so in such prisons, the prisoners serve 6 months sentence to life imprisonment one. The only difference among them is that they stay in different rooms. However, the treatment to them is exactly the same in terms of clothing or foods. So there's no different treatment towards different groups of prisoners. That's why I like to use the general regulations of international law and Vietnamese law to compare and see the similarities and the differences. So on the screen, you can see the different covenants and conventions. For example, we have international covenants on civil and political rights, or international covenant on economic, social, and cultural rights. And in the region, I also found the Inter-American Human Rights System with American Covenant on Human Rights, or the African Human Rights System with African Charter on Human and People's Rights, or the European Human Rights System with European Convention on Human Rights. And then I also find out the lawful health standards in prisons for lifers. For example, right to medical care, right to timely medical attention, right to adequate living space, right to hygienic living conditions, and right to mental health care. So according to Vietnamese law, I have looked at the law on implementation of criminal sentence. And in that law, there are regulations, detailed regulations on healthcare for lifers. However, in addition to some advantages, we also have some disadvantages in our law. First, regarding the detention of prisoners with mental health problems. Secondly, some disadvantages regarding the legal aid for lifers. And although our law stipulates that lifers are entitled to freedom of religion, however, the implementation of such regulation is very weak in practice. And not only in law, in practice, we also have other shortcomings. For example, there is still violence or fighting among prisoners, or like one prisoner may kill the other prisoners. Moreover, the overcrowding of our prisoners is also a problem. According to some studies, lifers normally stay in an environment which is not very good to their health. So after I compare the international laws and Vietnamese ones, I also make some comparisons, like to what extent is the Vietnamese law compatible with the international ones. So regarding the compatibility, it can be said that lifers in Vietnam can get access to healthcare timely in prisons. Secondly, they also receive a periodical health checkup. Thirdly, they are provided with clothing and blanket appropriate to the weather. Moreover, pregnant women and women with children under 36 years old get special care. However, there are some challenges faced by our legal system. There is still overcrowding in prisons. Secondly, the mental health care for lifers is not very good. And the COVID-19 pandemic affects not only people outside prisons, but also those in prisons. So there is still transmission among the lifers and between the lifers and the prison officers. Now I'd like to go to the conclusions. So after I do my analysis, it can be said that although the Vietnamese law still have some shortcomings, we can say that we have obtained certain achievements in in taking care of the prisoners' health, and the government are making efforts to ensuring the health for people outside the prisons, also those who have no freedom and stay in prisons like lifers. Thank you very much for your attention, and I wish you all peace and safety in the pandemic.
Prisons somehow like a hub of poverty, conflicts, and violence. And you also mentioned about rationale for paying more attention for life sentence prisoners. I believe that we would have interesting discussion later. Thank you. Now I would like to invite Dr. Trương Thị Hồng Hà and Ms. Đinh Kiều Trang from the Commission for Internal Affairs under the Communist Party to have the paper on renovating treatment of life sentence in Vietnam.
Good afternoon, ladies and gentlemen. Dear Chairman, thank you very much for having me. I and Ms. Chang here today. It is great honor to be with you. I would like to take opportunity to you about my subject, executions of judgments on persons sentenced to lie in imprisonment to meet the requirements of judicial reform in Vietnam today. My presentation is divided into 3 parts. I will talk about 1. Legal regulations on policies, conditions, and accessibility to rehabilitation for persons with life imprisonment sentence in Vietnam. Then I talk about 2. The implementations of legal regulations on policy, conditions, and accessibility to rehabilitation for persons with life imprisonment sentence in Vietnam. And finally, I will focus on solutions to ensure the rights of imprisonment. And finally, I will focus on solutions to ensure rights of life-term prisoner in Vietnam. Now, let me begin by 1. The legal regulations on policies, conditions, and accessibility to rehabilitation for persons with life imprisonment sentence in Vietnam. Firstly, the 2013 Constitution recognizes and guarantees the implementation of human rights and citizens' rights, requiring the continuous renovations and perfections of the legal system, particularly the penal codes and criminal procedure codes, and law and execution of criminal judgment, and as important legal tools in ensure and protecting human rights and fundamental rights of citizens for persons sentenced to life imprisonment. And may I, for example, Clause 2, Article 14 stipulates human rights and citizens' rights may not be limited unless prescribed by a law solely in case of necessity of the reasons of national defense, national security, social order and safety, social morality, and community well-being. Secondly, the 2017 Penal Code and the 2015 Criminal Procedure Code and the 2019 Law and on execution of criminal judgment as many provisions demonstrating the humanity for people serving life in prisons. The Penal Code 2017 stipulates the death sentence shall not be executed when the sentenced person is 75 years old age or older, and the person sentenced to death for employment or taking bribe after being sentenced has returned at least 3/3 or property emblems or bribes taken and grossly comparated with the authorized in the process of investigating or trial, or has made reparations on an effort to atone for the crimes. Many provisions on the reducing the decreased sentence for a person convicted of multiple crimes with a sentence for one of which being life imprisonment, and add a completely now provisions on conditional parole. Thirdly, life-term prisoners are one of the subjects covered by the law, and amnesty, which represents a major policy of the party and strengthening the guarantee of promoting of human rights in Vietnam, as well as the five traditional of our nations. In order to be granted special amnesty, life-term prisoners must fully meet following conditions: serving life imprisonment sentence which has been commuted to term imprisonment, having made a great improvement, showing a good sense of rehabilitating and being classified fairly good or good in serving prison sentence, must have served its imprisonment term for at least 14 years or 17 years, depending on type of crime. It continues to be granted a reduction of the imprisonment sentence serving term. The reduced period is not included in the period has been served with the imprisonment sentence. In order, the granted amnesty by the state president upon each dry amnesty person sentenced to imprisonment of corruption, crime, or some crimes shall have a completely served their additional penalties, including paying fine, damage compensations, and legal costs, returning access or other civil obligations. Two, let me show the implementation of the legal regulation of the policy, conditions, and accessibility to rehabilitations for persons with commencement imprisonment sentence in Vietnam. I saw the six advantages. Firstly, the detention regime for life-term prisoners shall comply with the provisions of the law and execution of the criminal judgment in terms of procedures, order, and time for sending people sentenced to life imprisonment to serve the sentence and publicizing the place resolving them. Secondly, the classifications and detentions of the inmates are specified and organized routinely and ensure strict discipline, greeting and safe and healthy educational environments for sentence serving of inmates which lie in imprisonment. Thirdly, the policies on food, clothing, studying, living, medical treatment, and education, rehabilitation, and vocational consultancy and training activity for prisoners have many innovations and are strictly implemented according to regulations reflecting humanities and greeting and favorable environments for life-term inmates to study, work, and rehabilitate.
I'm sorry, Dr. Ha. Could you come to the conclusion, please? You have only 1 minute left.
Okay. We turn to solution to ensure the right of life-term prisoners in Vietnam, raising awareness and renovating nation and educations of law and human rights for life-term prisoners, building and perfecting legal government relevant issues, and innovating policies, conditional and accessibility to rehabilitations, strengthening supervisions, and last, connecting life-term prisoner with society. And may I give conclusions? Because over part time, the legal regulations on policies, conditions, and accessibility to rehabilitation for life-term prisoner in Vietnam have changed a lot and improved in direction of better guaranteeing the right and legitimate interests of inmates serving life in prisons. Attention has been paid to education, correcting and converting prisoners by rightness and diversity, and having them to relate into the community regime and policy for prisoners have been guaranteed with a prison facility improved. The correctional practitioners have been given professional training to ensure regularity and professionalism. That's the outstanding results contributed to ensuring the strictness of law, respecting, protecting, and ensuring the right of the people suffering imprisonment sentence, maintaining political stability, social order, and safety, and creating a favorable environment for social economic development. In the coming time, it is necessary to take many effective measures so like imprisonment, prisoner can be rehabilitated to help the, into the community. That brings me to the end my presentation. Thank you for your attention and good health for you.
Thank you very much, Dr. Trương Thị Hồng Hà, for your overview of Vietnamese law and policies relating to the life sentence prisoners, and also have some suggestions for improvement. Thank you very much. Lastly, I would like to invite Ms. Kriti Khachi from Banastali Vidyapith University from the Rajasthan state of India, present her paper on effects of life imprisonment and crisis of prisoner health.
Hello everyone, this is Suti pursuing BA LLB third year from Banastali Vidyapith, India. My today's topic is effects of life imprisonment and the crisis of prisoners' health. So starting from the abstract, all prisoners should be treated with regard because of their inborn nobility and worth as people. The jail is an awful spot to adapt a genuine infirmity. The main reason for this is that the jail framework doesn't have staff or assets to deal with significant medical issues like coronary illness, health, HIV, hepatitis C, or tuberculosis. These prisoners have a countless history of hazardous health behaviors, including intravenous drug use, HIV, and much more that are uncontrolled in jail. Prisoners' medical conditions have interference related to the behavior determined in jail, relations with jail staff and officials, and the emergence results. One of the main reasons for prisoners' medical issues might be conflated incorrectly with wrongdoing is that medical services in prison is given an eye to decreasing expenses and depends on tactic model which expresses to be sound name. The inability to meet a detainee's essential rights to human respect is often a capacity of terribly under-resourced and disarranged jail well-being workers for hire. Employed by the state to reduce expenses, for-profit jail well-being suppliers have famously pitiful records with regards to regular jail life. Medical issues can affect all detainees, including, if not particularly, life-condemned prisoners. Now I will be moving ahead with effects of life imprisonment. It is essential to consider the potential detrimental effects of life imprisonment in order to understand the full implications of penal policy in that area. Such consequences are perhaps inherent to imprisonment in general, but they can't be intensified as a result of the way in which life imprisonments are managed. This kind of confinement creates serious psychological risks for prisoners. Many of them experience panic, anxiety, rage, depression, and hallucinations, especially when confined for long periods of time, some up to 25 years. Social isolation is usually an unavoidable result of long-term imprisonment. Offenders, having been removed from their social environment, tend to lose outside contact. The loss of relationships with family and friends is probably the most serious deprivation of long-term imprisonment. Prisons do not rehabilitate. In many cases, a person forced to spend his life in prison will not realize the consequences of the action. Furthermore, meeting with other professional criminals may lead to worsening of the criminal internal character and erode at his better qualities. This would serve as a greater burden on the taxpayers. The more criminals are imprisoned, the higher the cost of taxpayers incurs. Providing food and accommodation during the life of a criminal is expensive, as are the necessary medical services that he may need. While some of the better off taxpayers may be happy to pay the bill because they gain a sense of security, this would serve as a burden on other taxpayers. In addition, because many prisoners are clearly dangerous places from which there is no exit or escape, prisoners learn quickly to become hyper-vigilant and ever alert for signs of threat or personal risk. Because the stakes are high and because there are people in their immediate environment poised to take advantage of weakness or exploit carelessness or inattention, interpersonal distrust and suspicion often result. Moving with the health, prisoner re-entry and spillover effect. So first point says, by focusing on a representative sample of 1,100 former, mostly short-term prisoners, they find that nearly all suffered from chronic illness that required care. Many ex-prisoners had multiple medical needs. Although most participants in the study received some health care while imprisoned, their rates of treatment for special health conditions deteriorated, suggesting that they received episodic care for acute problems, but that continuous treatment of specific health conditions suffered. Returning prisoners with health problems may be unable to engage in work or other activities because of pain or sickness, and their families may be unwilling or unable to serve as a fallback support. They are additionally confronted with the task of managing their health problems, such as accessing health care and keeping up with medications or appointments. Those with severe or unmanaged health problems face an increasing risk of adverse outcomes, including physical illness, relapse into drug use, or particularly in the case of mental illness, inappropriate behavior that provides a police response. In case of life sentence prisoners released early, such challenges are likely to be exaggerated. Although some may be able to return to robust social networks after release, it is likely that most will confront serious health-related problems in the absence of sustained care that will make staying out of the prison much more difficult. Exploring health and re-entry beyond individuals, prisoners is of obvious importance. Several recent empirical studies documented how negative health care outcomes extended to ex-prisoners' families and had aggregate negative impacts on surrounding communities. Exploring health and re-entry beyond individual prisoner is obvious importance. So hence, I'm concluding my PPT, taking seriously concluding reflections on how prisoners can be transformed to prepare prisoners for successfully re-entry is of obvious importance. There is no doubt that maximum effort should be made to encourage ties with the family and community throughout the prisoner's stay. And pre-release programs should be focused on actively connecting the prisoner to the host community. The debilitating effects of prisoner on many prisoners' health and well-being must also be cornerstone of such initiatives, or in many cases, they will ultimately fail. Parole and probation services and agencies need to be restored to their original role of assisting with reintegration. Here, to the complexity of the transition from prison to home needs to be fully appreciated, and for parole revocation should only occur after every possible community-based resource and approach has been tried. Thank you.
Thank you, Kriti, for your interesting presentations.
Thank you,
Now,
sir.
I would like to invite all of you to join us in the discussion. We have around 15 minutes for discussions, dialogues, and Q&A. Do you have any questions or comments for our three speakers? Please send to the chat box, please. Do you have any question for speakers from Vietnam and India about right of prisoners, especially right to health? Yes, thank you, Lana, for her question to Mr. Bhatti. You mentioned the right of prisoners. The fundamental right of prisoner is the right to rehabilitation within freedoms. Do you agree that life sentence remove that right? Interesting question. Ms. Thuy, could you answer Lana's question, please? What do you think about the Lana's comments and question that the fundamental right of prisoner is the right to rehabilitation to win freedoms? Are you supporting remove life sentence? Dr. Trương Thị Hồng Hà, please. Christina is asking Lana to elaborate your question, but for my understanding, Lana want to know whether the speaker supporting to removing or maintaining the life sentence in criminal system. How about Kriti? Kriti, could you answer the question, please? Lana is sending another question for other Vietnamese speaker. Life sentence without parole is given for great crime. Great crime is a sign of depravity of a society, not depravity of the individuals. When there is a great crime, the rehabilitation of the society to be free is required. It must involve rehabilitation of individual to freedom. Do the Vietnamese speaker agree? Dr. Hồng Hà, how are you? Could you hear us?
I'm sorry. Now I can answer questions. I don't agree about this questions.
Why are you not supporting abolish life sentence?
Because I think the punishment for this sentence, and he can make in the prison, and this is time for them, and protect them and re-education, and
cũng như là được giáo dục.
Yeah, but I think he has a lot of opportunity to come to social.
Thank you, Dr. Hồng Hà. How about Thuy? In your paper, you also mentioned several countries. They move. You mentioned some countries in like Brazil or Portugal. They do not have life sentence. How about Vietnam? What do you think?
Thầy nói lại được không lại? Em rất khó nghe ạ.
In the criminal system. And Lana, she has a question for you. That do you support the life sentence or not? Do you think that life sentence should be moved out from the criminal code or not?
Tôi xin trả lời này rằng ạ, hiện tại thì tù trung thân ấy, ở Việt Nam thì tù trung thân gồm có hai loại là tù trung thân không ân xá và tù trung thân có ân xá. Thì theo quan điểm của tôi cho rằng mà để
opinion so as to guarantee the health of the lifers and also to facilitate them with the opportunities to be reintegrated into the society, I think life imprisonment can be handled in the way that removing the life imprisonment without parole, and we can provide them with longer sentence, and after some time of serving, they might be considered to come back to the society. So instead of continuing with the life imprisonment without parole, which can cause great mental distress to them.
From Dr. Dirk van de Smit, would you clarify the point that is in Vietnamese release a life sentence prisoners depend on being granted an amnesty? A prisoner is not granted an amnesty, can the prisoner ask the court to review the decision? First, please, could you answer about the Vietnamese criminal law, the code of 2017 relating to the life sentence and reducing the life sentence?
Thank you for your question.
Cô mà vào tai rất là khó để chẳng.
Firstly, my favor, I
trong bài thuyết trình của tôi,
prisoner,
thì
one
tôi
of the
cũng
subjects
đã nói
covered by the law on the amnesty. We can present a major policy of party and states, demonstrating as a guarantee and promotion of human rights in Vietnam, as well as five traditions of our nation. It reflects the strictness in educating offenders, as well on leniency and humanity towards inmates, showing improvement in the rehabilitating procedure as to help them return to the community as good and useful citizens.
Và trở thành một công dân có ích cho xã hội.
And I think the
tôi nghĩ rằng
Vietnamese law have
luật pháp Việt Nam
full and enough to
rất là đầy đủ,
stipulate
đã có những quy định rất là đầy đủ.
For the prison,
đối với
imprisonment sentence in Vietnam. In a person who's like imprisonment sentence in Vietnam. That's all. Thank you.
Thank you, Dr. Hà.
Tôi xin cảm ơn.
Ms. Thủy, do you like to add something on Vietnamese criminal law regulation?
Tôi khá đồng ý với ý kiến của tiến sĩ Trương Thị.
Okay, cảm ơn.
Và tôi muốn nói thêm rằng trong luật
that in Vietnam's criminal code also life imprisonment can be considered a very strict one, but the treatment for their health in Vietnam is fundamentally guaranteed, and the conditions for them to be granted with amnesty would require the efforts, their own efforts. So during the recent time, in 2021, Vietnam has had the time of amnesty for many prisoners, including those with small crimes or serious crimes, including life imprisonment persons, lifers as well.
May I interrupt you?
Dr. Lanchi?
Yes. There are some technical problems to have the and chairperson, please choose the right channels. If you like to listen and speak in English, please select English channels. And if you want to listen and speak in Vietnamese, please select Korean channels to have the interpreter to do his job well. In addition to the answers of Thủy and Han, I totally agree with the answer. I would like to give some further information about the commute sentence to the person who's convicted and sentenced with life imprisonment in Vietnam. According to the section 63 of the Vietnam Penal Code in 2015, the life sentence can be commuted by the court, but after serving 1.5 of their life, they can be commuted by the court. But after 20 years of serving their sentence in the prison, and we have another type of reduce the numbers of years in prison for life sentence. We have one section is similar to Paros in other countries. Were provided as section 66 of the Vietnam Penal Code. Thank you.
Thank you, Dr. Lan Chi. Do you have any further question for the speakers, please? Here we have a question from Marian Lê to everyone. Does Vietnam have an active prisoner exchange programs internationally where people from other countries sentenced in Vietnam to life imprisonment can be exchanged for a Vietnamese national imprisoned for life in other country? Very stressful and very interesting question. I would like to invite Dr. Hồng Hà to answer this question, please. Asking about the prisoner exchange program. Dr. Hồng Hà, could you answer this question? Or Dr. Lan Chi, could you answer?
In Vietnam, in our criminal procedure code, we have one part with regulations on international cooperation in criminal affairs between Vietnam and other countries, and in which we have provision on receiving and transferring the person serving penalties from Vietnam to other countries and from the other country to Vietnam. But in terms of the person serving life imprisonment sentence, what pity I have no practical information to give you the correct answer right now. Thank you.
Yes, I hope Lan Chi answer satisfies Mr. Marian Lê. There is also a question to Professor Hồng Hà. What reason that state should use to consider reduction of life imprisonment toward more time to serve, increase of integration to community for questionnaire period?
I'm sorry, dear Chairman. Now I go to other meeting in my office. I will answer all the questions in the chat. Okay.
Okay, thank you very much. Yeah, thank you very much. I know you are busy.
Yeah.
You're working for the party. You are always busy. Thank you.
Yeah. Thank you. Thank you so much.
Now we come to another question. Lana to Lan Chi. If you are talking about the right to release life sentence prisoner under amnesty, we Vietnam remove life sentence without parole. We Vietnam remove life sentence without parole. Also, can you or others Vietnamese speaker tell us what the budget is this year for specific rehabilitation, etc.? Lan Chi, could you see the question in the chat box?
Sorry, I have missed the chat box, but I think that if I understand your questions correctly, I have to say that in Vietnam there are many channels, many ways for the prisoner to be relieved, even they receive the life sentence. as I have mentioned before, we have patent, parrot, and computation by the decisions of the court. So I don't know what you want to ask me, about the life sentence without patent in Vietnam. Because these 3 channels does not mean that all prisoners with life sentence have the right to go out to free, to be released soon, instead of they have to confront the death in prison.
Thank you, Dr. Lan Chi. I'm very sorry that we have run out of time for this 4th sessions. I'm also sorry because we do not have any time to discuss with Kriti about Indian experience. I myself really like to know about the relationship between federal prison and state system in India. In other countries, managing the prisons is under Ministry of Justice, for example, in the United States or in China. But in Vietnam, the authorities the managing prison system is under the authority of Ministry of Public Securities mostly, and some prisons are under the Ministry of Defense. There is also some comment that Vietnamese law is relating to implementation Vietnamese law in practice, especially we look from the human rights perspective. Such as the issue of supervising, monitoring the prison system, for example. From the human rights perspective, I also think that human rights are interrelated. We could only protect prisoners' right to health when they have the freedom of expression, freedom of association, for example. And also the public have the civic space to supervise the right to information, to require the transparency from the prison system in Vietnam. Yeah, with that, I would like to conclude the 4th session here. Thank you very much for your interest in the 4 sessions. Now, I would like to invite Ms. Jennifer, Faculty of Law, University of Surabaya, Indonesia, to chair the 5th session, please.
Thank you, Mr. Tung. What a great session we had previously. I hope that all of us are able to understand and enjoy the previous discussion. Now, we will go on with the 5th session about the release of life sentence prisoners. We will have 3 papers in this session. The first one is about attempting to restore a right to hope of release, the Puongo case by Professor John Anderson, Ms. Hannah Williams, and Mr. Daniel Matas from University of Newcastle, Australia. The second one, we will have a paper about life imprisonment in India. When do we open the prison door? By Professor Suti Bhatti from Punjab University, India. The third one, last but not least, we will have a paper about release of life sentence prisoner in Vietnam by Mrs. Trang Quynh Chi from Ho Chi Minh National Academy of Politics, Vietnam. All right, so today in this session, we will have several points of view about the discussion about the release of life sentence prisoner from several point of view. So we would like to start with our first speaker, maybe Miss Hannah or Mr. Daniel.
Yeah, it's me,
the
Daniel.
floor is yours.
Thank you, everyone. It's a presentation by myself and my colleague Hannah Williams, solicitor. I'd like to begin by acknowledging the traditional owners of the land from which I'm presenting, the Awabakal people and Warramai peoples, and I pay my respects to their elders, past and present. The objective of our presentation in part this afternoon is to personalise the detrimental impact that a life sentence can have on an individual. And our case study is Phong No, who's a gentleman who's currently serving a life sentence without parole in prison in New South Wales. Just by way of a very brief background, Phong was born in Vietnam and came to Australia as a refugee in 1982 following the Vietnam War. And once in Australia, he quickly rose to prominence in politics and enjoyed great success. However, in March of 1998, Phong was arrested for the murder of a political rival, that being the late John Newman. And John Newman was killed some 3.5 years prior to that date on the 5th of September 1994. Now, at trial, Phong pled not guilty. And after 3 trials in June of 2001, he was found guilty of murder. And the jury in his trial, his final trial, accepted that he didn't carry out the killing himself, or found that he didn't carry out the killing himself, but rather that he'd arranged and organised the murder of the late John Newman. Just a little bit of a background on how the legislation worked at the time in New South Wales. Phong's finding of guilt meant that he was sentenced to life imprisonment for the crime of murder. I won't read out that subsection 1 of 61 that's on the screen, but you can see that the question of the imposition of a life sentence causes the court, as it was required to do at the time, to weigh the level of culpability in the commission of the offence against the community interests in relation to retribution, protection, and detriment purposes in place of punishment. Now, despite through a combination of the balance of those sections I have on the screen, 61 subsection 3 and section 21 subsection 1, at the risk of confusing you with the legislation, those sections allow a court to impose a sentence of imprisonment for a specified term in New South Wales and to fix a non-parole period. But the message I want you to get about that is that it's important to appreciate that a non-parole period can't be set for a term of life imprisonment in New South Wales. So when Phong was sentenced to life imprisonment in 2001, the judge in his case was satisfied that his motive for the killing of John Newman was, and I quote, naked political ambition and impatience, end of quote. And he likened that crime to an attack on parliamentary democracy. So in short, the judge, in applying these sections, and in particular section 61, was of a view that Phong's level of culpability was so extreme that the imposition of a life sentence in that situation, in his case, was warranted. But he did, however, go on in his judgment to encourage the New South Wales Parliament to consider changes that might be able to be made to the law to give courts the power to set or fix a non-parole period in cases where section 61 does apply. And it was very clear in his judgment that if he had the power, this is Justice Dunford, if he had the power to do so in Phong's case, he would have done so. But the law prevented him from taking that particular course. Now, unfortunately, to date, there's been no meaningful parliamentary consideration on that suggestion that was made. And I want to stress this point in particular. Phong continues to serve a life sentence without any possibility or any real possibility of parole in circumstances where for some 27 years now since the commission of that offence by somebody, Phong continues to maintain his innocence in relation to the crime. Moving on to a slightly different but related issue, we in our paper argue that Phong's treatment places Australia in breach of its international obligations. So Australia, the Australian government has ratified and is a signatory to the International Covenant on Civil and Political Rights, the ICCPR, and accordingly has committed to uphold the principles that are enunciated in that covenant. Article 7 of that covenant provides that no one shall be subjected to torture or cruel or inhumane or degrading treatment or punishment. And there's no real comprehensive definition of what that terminology means, but it's very clear that it, in addition to the physical, it also includes acts that might cause somebody to suffer mental harm. There are a number of cases that from the European Court that might guide us in this respect. So there's been very limited judicial consideration of Article 7. However, Article 3 of the European Convention on Human Rights mirrors very closely the wording of Article 7 of the ICCPR that Australia is a signatory to. Article 3 provides that no one shall be subjected to torture or to inhumane or degrading treatment or punishment. So the wording is very, very similar. So we argue that the interpretation of Article 7 can and should be derived from the meaning that the European Court of Human Rights has attributed to Article 3. And this, by extension, can provide some guidance on the question of whether or not Thong and others who are currently serving an indeterminate sentence in New South Wales, whether or not the government's treatment of those persons is in breach of Article 7. So without going through the case law, and I haven't got obviously the time to unpack it all, but in short, the European Court of Human Rights has consistently held that where the law does not provide a prisoner with any mechanism or possibility for release of a whole life sentence, then that law remains incompatible with Article 3 and thereby constitutes inhumane and degrading treatment. So we say that by extension, New South Wales' continued treatment of what we call lifers, such as Thong, sees our government remain in breach of Article 7 of its international obligations under the ICCPR. So I'll now hand over to my colleague and Solicitor Hannah Williams, who will speak on the possible way forward for Australia to ensure its compliance with its international obligations in this area.
Thank you, Daniel. Within our paper, we suggest that there are two remedies which New South Wales ought to look at to ensure compliance with the ICCPR. The first is a judicial redetermination scheme, which we've outlined. And Daniel, if you could please move to the next slide. We suggest that after having served a period of 30 years, that those sentenced to life imprisonment ought to be subject to a judicial review in which there is the opportunity at which a parole period may be attached to that sentence. The criterion outlined on this slide would be the factors that ought to weigh into that determination as to whether an individual would qualify to have their sentence redetermined. And the mechanisms by which we propose to introduce that are outlined in our paper. The next suggestion that we have, and if you could move the slide, Daniel, is in relation to the royal prerogative of mercy. It's our ultimate position that given the way that the reviews are conducted in New South Wales, that there is more transparency that is needed within this scheme, but also that a life manual akin to that in the United Kingdom ought to be introduced. All of that can be found in our paper, and throughout much of this process, it remains very academic as our focus. But what needs to remain at the heart of the reforms that we introduce is humanitarian considerations and the impact that it has on human life, such as that of Phong Ngo. When asked to comment on life imprisonment, this is the reflection that Phong was able to provide. I am Phong Ngo. I am 63 years of age. I am serving a life sentence without a release date for the murder for the State Member of Parliament, John Newman. I have been incarcerated for 23 years, 6 months, 21 days for a crime I did not commit. Even the Vietnam War did not last this long. People like myself in prison are called lifers. It's a misnomer. Lifers do not live, they just exist. To live is to be able to look forward to the next things in life. Lifers do not have that luxury, not even hope. Stepping into a prison is like walking into one end of a dark tunnel. Most prisoners will progress to the other end and eventually return home. Lifers do not come home. They remain in that dark tunnel of solitude. First, they lose their acquaintance, their friends.
Anna, can you proceed with the conclusion?
Family. If I might just sum up with this comment, Pope Francis has said that a life sentence is a death sentence in disguise. I think a life sentence is a prolonged death sentence. So that's where we wish to conclude our presentation with the remarks of an individual which is currently subject to life imprisonment without the possibility of parole.
Thank you, Ms. Hannah and Mrs. Daniel. Yeah, we are listening to the first point of view about the release, about the idea and the perspective about how we should restore the right or the hope for a life prisoner to see new hope of release. Now we will listen to the second paper from Professor Suti Bhatti from Punjab University, India. Please, Professor, the floor is yours.
Thank you, Ms. Jennifer. It's a pleasure to be here. And it was extremely interesting to hear to the previous presentation. And I think I can also relate to that and connect to what I have to present today. I will just share my screen for the PowerPoint presentation. So my presentation is basically on the issue of life imprisonment in India and the challenges that we are facing currently on two particular aspects of what is the nature of this life imprisonment, because we have the option of a simple life imprisonment, or you have a rigorous life imprisonment wherein you undergo hard labor during the time that you are incarcerated in the prison. And the second issue that I would like to deal with is that does life imprisonment mean the life imprisonment for the term of the natural life of the person? And that is where I think my presentation will sort of touch upon the same issue as the previous one by Mr. Daniel and Hannah Williams. I hope my presentation is visible to everyone. And briefly, before I start with the presentation, I'll just briefly take you through the historical aspect of how life imprisonment came into India and what caused the confusion for us during this particular period of time. So India became independent in 1947. And prior to that, we were a British colony. And at that point of time, the convicts used to be banished to the from the Indian territory, particularly to these Andaman and Nicobar Islands. It's a small territory next to in the Bay of Bengal. So it had a prison, a central jail where these prisoners used to undergo hard labor. It was an extremely difficult environment for them to survive, with the torture and other aspects being included in the nature of the punishment that they were undergoing. And at that point of time, particularly Section 55 of the Indian Penal Code provided that the punishment for transportation for life, which was actually a sentence to this Andaman jail, wherein the convicts were made to undergo hard labor. So transportation for life could be commuted to a sentence of imprisonment for a term which would be amount to 14 years. And this all was there prior to, at the time of the British. That is what the British used to do. And subsequently, after we became independent, in 1955, the Indian Penal Code was amended and life imprisonment as a term was introduced in the Indian Penal Code. And wherever the reference was in the Penal Code to transportation for life, it was substituted for life imprisonment. And this caused a great deal of confusion because there was no clarification which was given as to whether the life imprisonment would be simple life imprisonment or would it include rigorous, you would have to undergo hard labor, or would it be a simple life imprisonment? And therefore, when we speak of the challenges, because in 1950, the Indian Constitution came into force, and with it, the fundamental rights which were available to everyone, including prisoners. And the concept of prisoners' rights and protections came to be widely accepted, and it grew over a period of time. But we still see that a lot of the life convicts still have to fight for these rights, which may be available to them as a part of the fundamental right. And unfortunately, the law which has been developed by the judiciary in our country, as well as the confusion which has been generated through the amendments to the law, has added to the ad hoc attitude of the progress of these two issues. And therefore, these two issues of the nature of the punishment as well as the duration and term of the punishment, there exists a lot of confusion without clarification as to what does it mean exactly. I have before you the relevant extract of the amended Section 53 of the Indian Penal Code, which provides for two kinds of punishment in addition to other punishments. But since we are not dealing with that, I will restrict it to only these. So one is called imprisonment for life, and the other is called imprisonment, which may be of two descriptions, which is rigorous, that is where you undergo hard labor, and the other is simple imprisonment. So there was a lot of confusion which had been generated by this time. And this issue came up before the Supreme Court, the apex court in the country, in 1983 in the case of Naib Singh versus State of Punjab. And the court unknowingly, without really going into the depth of or the reason as to what is to be decided in the case, it relied on an old decision of 1945. 1945, we still had the Privy Council as the highest body or which used to give decisions, because at that point of time, India was still not a British colony. And this case which was relied on was Pandit Kishori Lal versus King Emperor of 1945, where the Privy Council had interpreted the old Section 58, which had been later amended, of course, and they said that when a prisoner had been sentenced to transportation jail, till the time he remained untransported, he would undergo rigorous imprisonment. He would have to undergo hard labor for the time being that he was in the jail. And the Supreme Court, relying on the 1945 decision, gave the same meaning that imprisonment for life, in their opinion, would mean rigorous imprisonment for life. And this kept on, and this was the decision which was held for most of the part of this century as well. And recently in 2016, the Supreme Court again had an opportunity to question and analyze the validity of the nature of the imprisonment, life imprisonment, in Ram Kumar's case of 2016. But unfortunately, again, I think it is a case of missed opportunity where the court did not go into in-depth analysis of this particular issue and simply dismissed the petition without giving a reasoned order. Coming to the next issue, which is the duration of life imprisonment, I have again a few cases here. The question being that does life imprisonment mean imprisonment for the life of the person, or can it be shortened to a particular period under any particular aspect of the law which is present in India? So here I have a decision of 1961 of Gopal Vinayak versus the state of Maharashtra, where the court had held that imprisonment for life would generally mean that the convict would remain in prison for his natural life until the time that it was remitted or commuted. So if it was not remitted or commuted, it would mean that the convict would be there for the remainder of his life. And of course, there are provisions for sentence shortening in the Indian law. We have constitutional provisions wherein the power is given to the president and the governor to grant pardons, remissions, commutations, reprieves, etc. The legislature has enacted under the Criminal Procedure Codes certain powers where power is given to the authorities to shorten the sentence, including a life sentence. And then there are regulatory provisions in the prison or the jail manuals which allow remission on account of good behavior and the kind of work that the convict may be doing to remit or commute the sentence. And it was with this point of view that section 433A was added to the Criminal Procedure Code in 1978. Because there was a lot of misuse of sentence shortening provisions. So this particular provision was added to the Criminal Procedure Code so as to deny any kind of premature release of the life convict before a period of 14 years. So there was no question of release or any kind of a remission prior to 14 years in case of life convicts. So he had to serve at least 14 years of jail time as per the amended Criminal Procedure Code. And this particular provision came to be challenged in 1981 in the Maru Ram judgment, where the court held that imprisonment for life would mean for the rest of his life unless he had earned some kind of a remission, and the prisoner could therefore only claim release from the remaining sentence if his sentence was remitted in any particular manner by the government. Now,
we proceed to the conclusion?
Yes, so I'll just conclude here that if you compare the law in USA or UK or in other countries where in USA, it is after 10 years that usually they're sent out on parole. And in UK, it is after 15 years through a decision of the Home Secretary. But here, the decision and the law which continues in India is that imprisonment for life continues to be for the remainder of the life. However, 2013 and 2018, certain amendments were again brought out, which added to the confusion because they now categorized imprisonment for life, which could be only imprisonment for life. And then they added another category saying that imprisonment for the remainder of the person's natural life. So currently there is no clarification in existence in the Indian law as to when we say life imprisonment, does it really mean life imprisonment, which can be remitted after 14 years, or does it mean life imprisonment for the remainder of the person's natural life? So I think because we are short of time, I will stop here and maybe we can go ahead later on with the discussion. Thank you so much.
Thank you, Professor Suti. Yeah, we can see that it's very interesting when other countries are fighting about how to make the sentence get shorter from long life sentence. Now India have only 14 years imprisonment. It could be a problem too, right? So we will discuss about this further. We will proceed with the next paper first before the discussion. We will listen from Mrs. Trang Nguyen Ki from Ho Chi Minh National Academy of Politics, Vietnam. Please, Mrs. Trang, the floor is yours.
Yes, thank you, Ms. Jennifer. Good afternoon, everyone. First of all, it's my honor to participate in our online international conference today. I'd like to thank all the organizers for providing an opportunity for me to present my paper, especially Professor Vũ Công Giao and Ms. Catherine Taylor. Thank you very much. Now let me introduce myself to you. My name is Nguyễn Quỳnh Trang. I'm a lecturer from Institute of State and Law, Ho Chi Minh National Academy of Politics, and I will show some of the main points in my paper called Release of Life Sentence Prisoners in Vietnam. In this presentation, I will divide into 5 sections. First, the general introduction of life imprisonment. Second, the definition under Vietnamese law. Third, the release conditions. And fourth, life after release. And finally, some recommendations. First, I'm going to present the general introduction of life imprisonment. Like many scholars mentioned yesterday, life sentence or life imprisonment has been continuing a controversial issue since diverse domestic regulations depend on their own culture, tradition, and legal thinking. But we could take the claim of the United Nations as a paradigm of life sentence, which means that a person must spend the rest of his or her natural life in prison. But it's not the end for the prisoners, because a sentence of life with parole is the most common type of life imprisonment in 144 countries, and 33 countries do not impose life sentence or death penalty as the ultimate sentence. Did you know that in Vietnam, only 1.16% of people granted pardon committed illegal acts and offending? In spite of different provisions and in different countries, we all see that life imprisonment goes against the value of international human rights. That's why there are some relevant general standards that restrict the overuse of life sentence. Those are the reasons why life imprisonment with parole will become an unavoidable trend heading towards minimizing life sentence in the world. As evidence of that, more and more countries abolish life imprisonment, and others try to decrease the number of years served by life sentence imprisonment. In Vietnam, according to Article 39, the Penal Code 2015, life imprisonment was defined as an indefinite prison sentence imposed upon people committing an extremely serious crime but not yet reached the capital punishment, and it shall not be imposed upon offenders under 18. Vietnamese law do not regulate the maximum duration of executing life sentence or divide into separate types, but it can be inferred that there are three cases: death penalty commuted to life imprisonment, life sentence with and without parole. Those are the foundation for the release of life sentence prisoners in Vietnam. That also is the next thing that I share with you. The release from life imprisonment is a part of Vietnamese pardon policies. It's explained in Clause 1, Article 3, Law on Pardon 2018, as a special clemency of the state from the President's decision on setting free convicted persons with determinate imprisonment, life imprisonment before the due date on the occasion of nationally important events, great holidays, or special circumstances. Fundamentally, a pardon is a state measure to absolution of all or partial punishment, but there is some confusion with parole, which is the measure from the court applying for persons serving the prison sentence when they have enough conditions following the Penal Code 2015 and Resolution 1/2018 of the Judges' Council of Supreme People's Court, because current parole regulations in subject conditions have similar points with pardon. Many opinions state that we need to differentiate clearly those two concepts. Therefore, lifers can be released in two cases. First, on the occasion of nationally important events, great holidays, recently often on Vietnamese National Day, 2nd of September, which is regulated in Chapter 2 of Law on Pardon. And second, in special circumstances to meet domestic and foreign affairs requirements in Chapter 3. So, if a life sentence prisoner wants to be granted pardon, what will he need to prepare? I want to focus on the first case, the proposed pardon file on the occasion of nationally important events. Great holidays include at least 6 documents, as you can see on the slide. The proposed pardon document is a part of the pardon order procedure, which are stated from Article 15 to 18 Law on Pardon and detailed in Article 578 Decree 52/2019 of the government. It can be summarized in this diagram. As we can see, the relevant authoritative organizations are multiple, but the essential role is attached directly to the President at the central level, and wardens of prison temporary detention at the local level. In the next section, I will show you the release condition for lifers in Vietnam. According to Clause 1, Article 11, Law on Pardon, a person sentenced to life imprisonment but has been reduced to prison with a fixed term to be proposed for pardon must fully meet all the following conditions. Besides, Article 12 also regulates cases that despite a person who fully meets the condition above, he or she still cannot request pardon in one of the following cases. So, what we are most concerned about is after release, how freed prisoners will contrive to move on in life. In fact, the situation of people who return to their localities after being released from prison without job or unstable jobs, a lack of capital, the number of people who are stigmatized and shunned by society is still high. Psychologically, after returning from prison, as prisoners often carry the inferiority of those who have committed crimes, while the vocational training in prisons and detention camps has not yet diversified in profession, or no vocational certificates. The attention and help of local authorities, unions, and related departments are still in the formality way. Especially in the COVID-19 pandemic, the process has some characteristics compared with normal day. After giving pardon certificates, the prison representative will distribute clothes, shoes, food, travel or community reintegration expense, and labor wages to inmates. The prison coordinated with local health centers to ensure strict epidemic prevention, like carrying out testing procedures and issuing certificates of COVID-19 test results, issuing masks and hand sanitizers for prisoners, and send them to localities by specialized vehicles. In order to help release prisoners, the government issued Decree 49/2020 detailing the law on criminal judgment execution on community reintegration from Article 9 to 12. By the end of this presentation, I will propose some recommendations. First, supplement regulation on the probation period for person granted pardon and the obligation of them during the period. Second, mobilizing enterprise, organizations, and individuals to participate in helping ex-prisoner. Third, determining the time and frequency of the pardon. Fourth, supplement regulation on organization or sanctions to check and evaluate the results of the request for pardon. Fifth, distinguish the conditions of parole and pardon. And finally, measures to prepare for reintegration and measures to ensure reintegration should not be divided, but both can be applied before, during, and after the prisoner's release. Because the time limit is over, I have to close my presentation here. If you want to know more information, please take a look at my full paper. Finally, I sincerely appreciate that I have this opportunity to present to you. Thank you very much for your time and attention. Thank you.
Thank you, Mrs. Trunk, for the great presentation. We have a very great time to listen to your paper, a very clear explanation about the Vietnamese rules about the parole and the pardon for in Vietnamese law. Thank you. Now we will go on with our discussion. So for everyone who want to discuss, you can send your questions in the chat and we will proceed with the speakers. All right, so we will go on with the first questions from Wang Quang Duc for Miss Hannah Williams. From your case, is there any possibility, according to the author, that the court is biased in conviction of grounds? Can you elaborate?
Oh, fantastic. Sorry, I think I just dropped out momentarily. To respond to that question, In terms of the conviction in Mr. No's matter, there are a number of legal concepts in which we find that there is some question over how the conviction was reached. Of note, in the trial, there were two co-accused that were also tried at the same time as Mr. No. And the two co-accused, one of whom was alleged to have pulled a trigger, was acquitted. And this is known as a joint criminal enterprise when you have three individuals who are allegedly conspiring to conduct such an act. And so it's our ultimate position that there are a number of legal concepts which remain.
Hello, Hannah. I think her connection is down. All right, maybe you can proceed with Mr. Daniel or Sir John, Professor John, since Hannah is having a problem with her connection.
Yeah, so as Hannah was mentioning, there were two co-accused in Fong's trial, and both of those persons were acquitted. And Fong was obviously the individual who was found guilty of the commission of the offence. Now, both of those individuals were also of Vietnamese origin. So to suggest, I think it would be difficult to suggest, and I wouldn't be suggesting that race had any part in the decision that was handed down by the court. And I noticed in the chat that somebody had said that at the time in Australia that there was some suggestion that the area, Cabramatta, in which Mr. No and others from the Vietnamese community resided, there was a drug trade problem and supply problem, and there were a number of individuals who at the time weren't happy with the late John Newman, who is the deceased party. And initially, during the investigation, No wasn't the only suspect. In fact, he wasn't even the first suspect, but it was rightly or wrongly, we say wrongly, later decided that he had much to gain from the removal of John Newman from his position, and that related to his political ambitions. We, of course, and No, of course, denies that. And my own view is that we have some very strong evidence that suggests that he wasn't politically motivated. And in many ways, if you take away that suggestion that he was politically motivated, then there really is no reason why he would want to have John Newman removed. I'm not sure if that answers the question, but in terms of race, I don't think that it played any part in the court's determination of Mr. No's guilt in terms of the trial.
Thank you for jumping in there, Daniel. I apologise, I momentarily dropped out, so thank you.
All right, thank you, Daniel and Miss Hannah. All right, so for the other questions about the statement, maybe we can proceed with sending it by chat, because it will take quite a long time, and then we can proceed with another discussion first by while others can read the statement. All right, and then let's proceed with the next questions from Professor Suti Bhatti. From NVU Master Students of Human Rights Law in India, is there an independent monitoring mechanism to check the sentences pronounced by the judiciary, to produce statistics and report on the court activities related to sentencing of life imprisonment? Thank you. Please, Professor Suti.
Thank you so much for this question. Actually, we have not only for life imprisonment, but we have a national bureau of for recording crimes. It's called the NCRB, which is the National Crime Record Bureau. which monitors the crimes which are being committed in a particular, so they take 1 year as the base wherein they will record the number of crimes which have been committed. And then commensurate to that, they will also see the conviction rate in that and the punishment which has been awarded. It could be life imprisonment or it could be any other form of penalty which may be imposed. So we have a mechanism to monitor the statistics, but whether or not the judiciary is actually correctly applying the law is another question. And whether it is deciding the matter particularly on the facts of a particular case, or is it according to the law which is prevailing at that point of time? I hope that will answer that particular question.
All right, thank you, Professor. There is another question. The question is, is there an independent, I'm sorry, wait. All right, if India currently sentenced, is there any provision that when a person commits many crimes and is sentenced to many sentences, how will the summation of punishment be done and applied according to the maximum penalty? Why they take 14 years to be maximum number of years to serve a life imprisonment in India? A very interesting question. Please,
yes.
Professor.
Thank you for the question. Indeed, very interesting. So in India, we have this policy of, when there are multiple sentences, the question before the court has been, and that was the latter part of my presentation, that would those sentences run concurrently or would they run consecutively? Consecutively, we see that in most of the countries around the world, it is consecutive. But in India, the law is that these sentences run concurrently, wherein they are superimposed on each other, which means that they are running simultaneously. The person is carrying out or undergoing the sentences together. However, it again depends on the crime which has been committed and the duration of the punishment which he has been awarded, which means the time for imprisonment. If it is life imprisonment, the same principles will apply. So here again, there is a link to the next question which has been asked, that 14 years is taken as the minimum sentence for life imprisonment. Now, here is where I want to clarify that the law in India is yet unclear. There is still a lot of confusion regarding this, and that is what I was trying to highlight in my presentation, that there is no clear-cut criteria as to for which offense you can have life imprisonment, which will be 14 years if it can be remitted. And there are certain crimes which have not been outlined again, wherein the life imprisonment means no remission after 14 years also. So it would mean life imprisonment for the remainder of the person's life. And that is where the confusion lies. And when I talk of concurrent sentences, coming back to the first question, and the sentences superimposed on each other, then in that situation, if a remission occurs for a particular sentence, it is only for that sentence. It will not apply to the other sentence. So depending on how the remission is occurring, if it is on good behavior, then maybe it occurs for all the superimposed sentences together. But if it is for another reason, if it's a presidential reprieve or a remission, it could be for a particular sentence, and that is where the term of that sentence would be shortened.
Great, thank you, Professor. Maybe we can proceed with the last one for Professor John Anderson. The determination of a life imprisonment sentence aimed to protect the human right of prisoner. It should belong to the responsibility of the state and should be actively reviewed on the whole prison system, and don't need the prisoner to submit an application to ensure the equality, and non-discrimination. What is your opinion regarding this matter? Please, Professor?
Yes, I can respond to that. Thank you. Yes, the redetermination system we did have in New South Wales for life sentence prisoners who was sentenced before 1990 did proceed upon an application by the prisoner, but it did really disclose or show how the importance of rehabilitation and the importance of what happened to the prisoner during their whole prison sentence was an important part of whether or not they should be released or how their sentence should be redetermined. So the proposal that we were making in relation to the Phung Ngo case in relation to redeterminations generally and looking at life sentences after a particular period would be really a review after a particular period of time without necessarily an application being made by a prisoner, because I do agree with the point being made there in that question that there is really a responsibility on the state here for rehabilitation, reintegration programs, and the way that the prisoner's time in custody is spent in relation to a potential release. So there should be a redetermination scheme that automatically applies after a certain period of time for review, but of course based on reports and other things that happen during the period of time in custody. So yes, I think it should be a state responsibility within a redetermination scheme, and we would certainly, that would be something that comes out of our proposal for a redetermination scheme as part of.
Seems to be very clear and has not been much debated about. However, things seem to have changed when studying the nature of life imprisonment. And from the perspective of the Vietnamese Penal Code, the definition of life imprisonment is a kind of indeterminate sentence, imprisonment. And in the 2015 Penal Code, some say that with the reduction of death penalty, Vietnam should have the kind of life imprisonment without parole. But the Vietnamese Parliament, or we call it National Assembly, did not agree with that. Did not agree with the introduction of the life imprisonment without parole. So that we can facilitate them with the possibility of coming back to the society. So when studying the situation, we see that in terms of the objectives of the penalty, it always arouse debate. However, together with the development of the society, the objective of the penalties have also seen with more progress and improvement, not only with the purpose of punishment, but also with the deterrence and educating purposes as well. The first view is that the objective is of the penalties is only deterrent and education. The second view is that there is also another objective of the penalties, which is punishing. And the third view, which is a kind of neutral, in the middle, moderate, saying that the main objective of the penalty is the educating and deterrent. We are supporting the view that the penalties should be aimed at deterrent and educating. We think that life imprisonment is without the limit of time, and for the particularly severe crimes, but not to the level of death penalty, and it is not applied under 18 years old people. And our laws have also added with the kind of conditional release before the end of the term. And there have also been the kind of comments in terms of our views like this. The life imprisonment is always existing in Vietnam's system of penalties, and it is stipulated and applied with the kind of particularly serious crimes. But the tendency is to narrow the scope of that, and it has been removed with some of the crimes like infringement of property or economic crimes. For such crimes, it has been removed with the LI. In the 2015 Criminal Code, the tendency of reducing the offenses with death penalties and life imprisonment has been quite clear. However, there are still things to be discussed about that Criminal Code. And for a long term, the views of the objectives of the penalties remain unchanged, considering that penalties are mainly aimed at punishing, which has been impacting on the Vietnamese penal system. That is in the past, right? And secondly, among the disadvantaged people, only the people under 18 are free from life imprisonment. For other group of people like the elderly and women, they can still be subject to life imprisonment. Although death penalty and life imprisonment have a different level of severity, but we have seen the interconnection. And number 4, the imprisonment stipulation of not more than 30 years in Vietnam. It has limited the kind of motive for making oneself, making efforts to be better. Yeah, because in Vietnam we have only the term sentences, not more than 30 years, and the next one is life imprisonment. So it is somehow not quite encouraging them to make efforts themselves to be better, the prisoners. So in the judicial reform, we have some solutions, some recommendations. First, to reduce the numbers of death penalties and also life imprisonment, and increasing the amount of penalties without imprisonment. For example, monetary fines, or reforming without detention. Yeah, without detention. And also we have some other recommendations to further improve the legal system in Vietnam. For example, we see the need to further improve the LS life sentences. For example, we need to define clearly and rationally the objectives of the penalties, of the sentences, and we need to change from tù chung thân, life imprisonment, into tù không có thời hạn, imprisonment without a term. And we need to make consideration so that in addition to the group of people who are under 18 years old, life imprisonments shall not apply to other groups of people, either like people from 70 years old or older, or women. They should not be imposed with life imprisonment either. And we also ask that life imprisonment should only apply with some kind of groups of crimes, like infringement of national security, genocide, crimes against humanity, murder with drugs-related murders, and some infringement of personal properties like robbery, kidnapping for ransom, and also kidnapping, abduction, and also something like embezzlement, receiving bribes, or infringement of the public safety. Yeah, this is our presentation. Thank you for the attention due to the time constraint. So I hope that we have more questions to be answered during the Q&A session for further clarification. Thank you for your attention. Thank you.
Thank you so much, Dr. Pham, and you kept perfectly to time. Please put any questions you have in relation to that paper in the chat. And thank you for stepping in to present that paper at the last minute. We now move from Vietnam to Japan, and we will hear from Mr. Teppei Ono of the Center for Prisoners' Rights on Life Imprisonment in Japan, Existing Legal System and Alternative Sanctions to the Death Penalty. Wonderful to have you here, Teppei, and very much looking forward to your paper. The floor is yours.
Thank you very much. So I'd like to overview the life imprisonment in Japan. The Japanese life imprisonment has the possibility of parole, but the chance to be parole has been getting slim. Basically, fewer than 10 inmates are released each year out of 1,800 serving life sentences. Most of the life sentenced inmates die in prison. It is difficult for them to get paroled and reintegrate into community. On the other hand, life imprisonment, especially those without possibility of parole, what is called LBAP, has often been discussed in the context of abolishing death penalty. Some lawmakers and lawyers groups, including the Japan Federation of Bar Associations, have been considering the introduction of LBAP as an alternative sanction to death penalty. So today, I'd like to focus on the current life imprisonment in Japan. I do not have time to cover the detail of the arguments over the alternative sanctions. So if you are interested, please refer to my paper. First, I'd like to show you some statistics to grasp the reality of life imprisonment in Japan. This table shows the average term of years served by life-sentenced inmates parole. Life-sentenced inmates released on parole served an average of 20 years and 10 months in 1998, but the average term of imprisonment has become longer. It reached 31 years and 10 months in 2007 and has not been shorter than 30 years since 2009. The 19 inmates who were paroled in 2019 served an average of 36 years in prison. Given that the average term between 1989 and 1998 was from 18 years to 19 years, the term has almost doubled in the past 30 years. Then what has made the possibility of parole so limited? In the background are the parole standards that tolerate continued incarceration despite the rehabilitation of inmates, and the parole boards that are susceptible to input from prosecutors and victims. The Penal Code provides that when an inmate evinces signs of substantial reformation, the person may be paroled after 10 years in the case of life imprisonment. A Ministry of Justice ordinance clarifies some additional requirements that prisoners must meet in order to obtain parole. Of these, particularly important are the following two. One is a feeling of repentance. Parole will not be granted unless inmates have a feeling of repentance. These requirements presuppose the admission of guilt. Therefore, when inmates deny the criminal charges and seek a retrial, they will not be released on parole, even if they meet all other requirements. The other one is the feeling of society. Inmates will not be paroled unless the feeling of society endorses it. It can be examined by taking into account inputs from victims and prosecutors. Therefore, parole may not be granted when victims or prosecutors oppose it. Then move on to the parole review procedure. The decision to grant parole is made by regional parole boards. They hold hearings if the wardens of penal institutions submit the proposal for parole, or if the board themselves find it necessary. The notice issued in 2009 states that a parole board may consider the possibility of parole after a life-sentenced inmate had served 30 years in prison. The term of 30 years was chosen to reflect parole practice at that time, as well as the fact that the maximum term of a fixed-term sentence is 30 years. Since the notice was issued in 2009, the average term of imprisonment for life-sentenced inmates has not gone below 30 years. Currently, parole board never hold hearings for life-sentenced inmates serving less than 30 years, and let alone 10 years. The minimum term of 10 years prescribed by the Penal Code has become almost meaningless. The minimum level of safeguards in case of rejection is not given to the inmates. Even if the parole board has denied their parole, they are not allowed to appeal the rejection, nor do they have access to the grounds for the denial. They also do not have the right to be represented by lawyers. Then what is limiting the chance to be paroled? One of the keys to figure this out is prosecutors' opinion. The statistics shows that prosecutors' involvement have a significant impact on parole review. Out of the cases in which prosecutors expressed opposition between 2010 and 2019, only 16% were allowed parole, contrary to the prosecutor's opinion, and 83.6% were denied. On the other hand, when prosecutors did not oppose parole during the same period, it was granted in 68.8% and denied in 31.3%. The Supreme Public Prosecutor's Notice issued in 1998 has been further strengthening the power of prosecutors. The target case of this notice is those as vicious as cases involving the death penalty. Yesterday, Professor Ishizuka mentioned such inmates as special lifers in his presentation. In such grave cases, this notice required the prosecutors to take steps to prepare to express their opposition to parole immediately after the life sentence has become final. According to this notice, it has been established from the outset of the imprisonment that the prosecutors will oppose future parole. Therefore, it is highly likely that such inmates will never be released on parole, no matter how they have been rehabilitated. But the fact that Supreme Public Prosecutor's Notice applies to their cases would never be informed to the inmates themselves. It is often said that there is little merit in asking for input from prosecutors, as the objective aspects of offenses and the prosecutor's view at the time of conviction are well recorded in the case files. Their intervention could bring about an unacceptable distortion of parole hearings.
You have 2 minutes, Pepe. Thank you.
Okay, to conclude my presentation, it will be essential to establish an effective parole review procedure to reform the current life imprisonment. Such reform include amending the parole standards, which require inmates to admit their criminal charges, prohibiting prosecutors' involvement in the parole process, and providing inmates with minimum level of safeguards, such as the right to know the reason for parole of denial, the right to appeal a denial, and the right to be represented by lawyers. Thank you very much for your kind appreciation.
Many thanks, Pepe, for your very clear presentation. Now we move from Japan to Indonesia. We have Dr. Go Lizanawati from the University of Surabaya, who is going to speak on the judge consideration in imposing life imprisonment, balance, justice, perspective. So many thanks to Dr. Go.
Thank you, Dr. Kevin. Ladies and gentlemen, good day and good afternoon to every of us. And it is such a blessing for me to be here in the middle of the expert colleagues and excellence attendees. My name is Guli Sanawati from Faculty of Law, University of Surabaya, and I'm sending you my sincere greetings from Indonesia. My paper title is The Judge Consideration in Imposing Life Imprisonment, What is Balance, Justice, Perspective? So before I proceed to explain my paper, actually I want to revise a small typo that I made in my paper. I unintentionally write the human rights law is law number 29 of 1999, but it is actually 39 of 1999. I'm sorry for my mistake. So ladies and gentlemen, this light paper and simple paper that I write is actually to provide the information concerning the Indonesian perspective on life imprisonment as exists right now. I will like to share you how is the Indonesian Penal Code perspective and also the specific criminal law outside the Indonesian Penal Code arranged about this type of sanction. And I share also the updated issue of life imprisonment in the perspective of the Bill of Indonesian Penal Code. This bill that has been drafted since 1964 for the first time, and it has been revised many times. And thanks God, but right now it has been the bill has been sent and also passed to the legislative, and hopefully it will be implemented in the nearest time, because there's a lot of reform in the criminal law due to our Indonesian Bill of Indonesian Criminal Law Code. After knowing the introduction of the updated life imprisonment, now and then I would like to exercise this the life imprisonment through the court decision. Try to understand what is the consideration of the judges, and also that we have to look through some cases. The problem of criminal law is actually the paradox of the parties that needed to be protected equally as formulated in the punishment theory, inter alia to the development of crime itself that has been increased both in the quantitative and also qualitative. This will lead us to a deep thinking, do we need only severe punishment to punish the accused? The presentation will not repeat it about the implementation of life imprisonment in Indonesia, since it has been discussed by our colleagues from Islamic University of Indonesia yesterday. So the paper will emphasizes to the effort to seek the answer. What is the consideration of the judge when impose the accused with a life imprisonment? So to understand this topic to my paper, I put an analysis that the balance justice must be brought to give the strict consideration whether the court must be imposed with severe punishment only, or considering to give punishment that can be helped to the accused to be a better person. Yeah. So this is here is outline of my presentation today as appeared in the screen. There will be 5 parts to be discussed, but it is depending on the time. I move the justification based on criminal imposition against the perpetrators of crimes is actually lies in the existence of occurrence of the crime itself. In its regard, every crime must have consequences imposing a sentence on the perpetrator. The retribution aspect is a must according to justice and according to the law, but the necessity aspect, according to the justice and also to the law, is also a must and absolutely, until every exception or any restriction solely based on a goal must be ruled out. In the criminal system in Indonesia, life imprisonment is an alternative to the death penalty to offenses punishable by a maximum death sentence. So crime prevention with the use of criminal law is the best method as old as human civilization itself. The presence of criminal sanction in a crime prevention criticism, stating that criminal is a response of our inhumanity in the past which should be avoided. Imprisonment remains in the criminal sanction system and still become the most often imposed sanction by the judge in deciding the case, and imprisonment, execution, prisons in Indonesia are implemented through the penitentiary system. Even though right now our government also has tried to advise to avoid to give prison as long as it can, but still it becomes the most often imposed sanction. As one of the severe punishment, life imprisonment must be given guidelines, clear guidelines before its implementation. And in the Article 10 of our Indonesian Penal Code, we have 2 model of sentencing. First is called as the primary sentence, and the second one is additional sentence. The primary sentence include the death penalty as the highest sanction, and then imprisonment in the second place, both life and temporary, and then privileged treatment of called as a custodia annesta, and fines and also light imprisonment. But the Indonesian Penal Code did not give further explanation about life imprisonment and its mechanism. This lack of information and mechanism has been responded in the Bill of Indonesian Penal Code. And this bill has put the guidelines about the punishment, and for the detail you can read my paper. Regarding the imprisonment system, the design of imprisonment is actually for retribution or retaliation elements using correctional institutions. These plans are contrary to the concept of social rehabilitation or healing and reintegration. In purpose, through the system, the offender will know what is their act and realize that it is a crime. Thus, through correctional, the offender of crime has no intention to commit a crime again. So there is a case, I move forward. The case of that I put as a case that I've been analyzed. There is a case of premeditated murder and child abuse result of serious injury that conducted by Alvi. In this case, the judge give some consideration that first, defendant has been proven committed premeditated murder and child abuse that result in serious injuries. And the second way, by considering the consequences of the action that caused the victim's death and also the witness have severely disabled. The Supreme Court considered itself on the length of the sentence demanded by the public prosecutor, which is required 20 years or life imprisonment. So this criminal imposition has been deemed fair and proper and by the sense of justice in the society, then the Supreme Court has given that life imprisonment. And the rest cases mentioned in my paper is related with the circulation of narcotics. And after studies some cases, it can be seen that for the similar issues of violating some specific article in the narcotics, but it brings a different sanction. Some punish with a capital punishment and others is with life imprisonment. So here, punishment must be not imposed on the defendant if the criminal activities were not according to the imposition itself. This just lends us that criminal sanction must be following the criminal act or actus reus. It is based on the
2 minutes. Thank you. 2 minutes left.
Yeah, thank you. And the retributive theory as retaliation for the defendant, but in every decision must consider the balance of justice protection. For the conclusion, the problem of life imprisonment model of sentencing must be careful understand. The existing law, Indonesian Penal Code and other specific law outside Indonesian Penal Code never give the reason of imposing offender with life imprisonment. But it can be learned from what is formulated as the maximum penalty and to replace, for the alternative of the death penalty. So the balanced justice must be carefully taken by the judges in considering the sanction imposed for the defendant in certain characteristic crime. So that's all my presentation. Thank you for listening, and I send back to Dr. Catherine. Thank you.
Thank you so much, Garo. Really interesting. So we're moving now from Indonesia to India. I'm delighted to introduce Mr. Himanshu Kalita from Gauhati University. He's going to speak on life imprisonment in India from a human rights perspective, issues and challenges. Please take the floor.
Thank you so much. Hello, everyone. My name is Himanshu Kalita, and today we'll be presenting our paper on life imprisonment in India from a human rights perspective, issues and challenges, along with my co-author, Ananya Pathak. We are both students of Gauhati University, India. To start off, let's go on to the evolution and history of life imprisonment. So when the British came to India, they brought the concept of transportation of prisoners, which as a reform to death penalty or mutilation. So death penalty or mutilation was there before the British itself. So when there was the Mughal era and the kings who ruled India, imprisonment was a punishment that was seen in that time as well. There was mutilation, there was death penalty as well. So when the British came, they brought the concept of transportation, and the prisoners were taken off to a remote island, the Andaman and Nicobar Islands, which the previous presenters, Professor Suti highlighted as well. So in the year 1955, Section 53 of the Indian Penal Code was amended, and imprisonment for life was added, substituting transportation as a punishment. So transportation was substituted by imprisonment for life in the year 1955. Section 45 of the Indian Penal Code gives us a definition of life imprisonment, and it reads as life till the death, till the natural life of the person who was imprisoned. Moving on to the Indian scenario, the whole judicial scenario revolving around life imprisonment. So there has been much deliberation, in the by the Supreme Court of India regarding the meaning of life imprisonment. In the case of Gopal Vinayak Godse versus State of Maharashtra and others, in the year of 1961, it was held that unless the sentence of life imprisonment was commuted or remitted by appropriate authorities as per the provisions of the Indian Penal Code or the Criminal Procedural Code of India, it was to be considered that a prisoner sentenced to imprisonment for life is bound in law to serve the whole time of his life in the prison. So this was a landmark judgment. Under Section 53 of the Indian Penal Code, there are two types of punishment that is given. One is imprisonment for life, and the other being imprisonment, which is of two descriptions, namely rigorous, that is with hard labor, and simple. In the landmark case of Naib Singh versus State of Punjab, the petitioner served 14 years in prison and appealed that his sentence should be deemed to have been commuted because he has already served 14 years in prison. And it was in India, the judicial precedents in some cases, it is said that 14 years is a time when after which the prisoners who are sentenced for life imprisonment are commuted or their sentence is remitted. So the petitioner in this case did the same. He appealed to the court that his sentence should be commuted. The Supreme Court rejected this plea and held that a 1955 amendment of the Indian Penal Code substituted transportation for imprisonment for life, but the nature of punishment remains unchanged. So in this case, the Supreme Court relied on a section 58, which is which was set by the in a case by the Privy Council in the times of British colonial times, and that particular section is now has been amended. So this particular judgment is not accurate and should not have been the case, as the Supreme Court said. In Subhash Chandra versus Krishan Lal and others, the court held that the appellant would be subject to life imprisonment for the rest of his life and will not be entitled to commutation under any available measures. So there are some particular judgments wherein the court has said that the particular appellant, the petitioner, do not have any right to get a commutation or a remission for their life imprisonment. The issue of length or duration of life sentence was addressed in the case of Swami Shraddhananda versus State of Karnataka, where the court held that the convict would be imprisoned for the rest of his life instead of death penalty. So there are cases where death penalty was awarded by the court, and where the further review was done, further appeal was done by the appellant or the petitioner, the sentence was changed into life imprisonment from death penalty. I think a lot of people would know here that there was a famous rape incident in Delhi in 2012, and there were a lot of protests, a lot of public outrage over it. So there was an amendment because of it, and the law was amended in 2013. So under this amendment, section 376A was added into the Indian Penal Code, which states that a person who commits the crime of sexual assault and inflicts injury to the victim that causes death or a persistent vegetative state shall be subject to life imprisonment. The period of imprisonment shall not be less than 20 years, and it can extend to the natural life of the prisoner or till death. Subsequently, in response to another famous incident involving the brutalizing of children in 2018, led to another amendment, that is the Criminal Law Amendment Act of 2018, which brought in the provisions for life imprisonment and even death penalty for those committing the crime of rape against minors. In 2015, the Supreme Court, in the case of Union of India versus Sriharan Elias Murugan and others, was asked to consider the validity of the court's power to substitute death penalty by life imprisonment and restriction of remission in such cases. So in this case, the validity of the court's power was challenged. The court in previous cases substituted death penalty by life imprisonment and also restricted remission. So in this case, it was challenged. The court held that it can indeed place a life sentence beyond remission for a predetermined time. So the court can actually place a life sentence beyond remission and can set a particular time for which no commutation or remission will be given to that particular prisoner. The dissenting judges in this particular case, the ratio was 3. So there was a 5-judge constitutional bench, and the 2 dissenting judges made a point that creating such a special category would make for a new type of punishment. So those judges said that if we place a person on life sentence beyond remission for predetermined time periods, it would create a new category of a new punishment. So the lack of clarity and uniformity in the court's approach to life imprisonment was well understood. The reliance upon this case in Sriharan brings to light the amount of distrust the judiciary has for the executive in the power of granting remission. So in India, under the relevant provisions, it is the executive which can grant remissions. The judiciary, in this case, the judgment showed that the judiciary indeed does not have a lot of faith in the executive in granting remissions. So it set some particular time periods beyond which remission was not to be served. This can also lead to lower courts using death penalty more liberally, knowing that such prisoners can get a life imprisonment without remission instead. So this judgment set a precedent that the lower courts were given more liberty. They consider that they can give life imprisonment more easily now, because ultimately those prisoners are gonna go for review in the higher courts, and they will be granted a life imprisonment instead of death penalty. So that's another case.
2 minutes left, Himanshu, thank you.
Okay, I will conclude. Okay, so prison conditions like overcrowding and shortage of staff, underfunding and violence are prevalent in the Indian prisons. The staff to prisoners ratio in India is 1:7. So for each 7 prisoners, there's only 1 staff in the prisons. There is constant violence due to torture, discrimination, and abuse of the prisoners. There is gross underfunding, and overcrowding is, of course, visible. So international law, ICCPR and UDHR has laid down certain provisions regarding imprisonment and the punishment, human dignity and rights as well. India is a signatory to both UDHR and ICCPR. The United Nations in a pocketbook of international human rights standard has laid down various rights of prisoners. The first would be right to physical and moral integrity, right to adequate standard of living, health right of prisoners, making prisoners safe places, making best use of prisons, complaints and inspection procedure. To conclude, I would move on to conclusion. The judicial interpretation and policy pertaining to life imprisonment in India is very aberrant and is not justified. There is no clarity about life imprisonment, whether it is simple or rigorous, and what that means for the prisoners. International law and human rights must be respected in the matter of life imprisonment. Human dignity and liberty of the prisoners must be protected. And social rehabilitation of the prisoners should be the main aim of imprisonment. India in particular has a long way to go, and the judiciary, along with the executive in India, should come up with concrete policies in the matter of life imprisonment. Any confusion or inconsistency in this regard should be clarified and dealt with. Thank you so much.
Thank you. Many thanks, Himanshu. Very interesting presentation. Do add questions into the chat, everybody. So we're now moving back to Indonesia for our 5th presentation in this session. It's one on human rights fulfillment for life imprisonment sentences, the cases of Indonesia, by Ms. Devi Yusvitasari from Ganesha University of Education in Bali. Please come in. The floor is yours.
Thank you so much. Good afternoon, everyone. We are Desi Yunitasari and Devi Yusvitasari from Ganesha University of Education in Bali, Indonesia. Thank you for giving us this chance to be a part of this great conference. In this opportunity, we would like to present about our research paper of human rights fulfillment for life imprisonment sentences, the case of Indonesia. Indonesia is a country that upholds the law, always bases it on every aspect of life. Law in Indonesia itself has governed many aspects of life, such as in social, economic, cultural, political, and so on. This is regulated in Article 1, Paragraph 3 of the 1945 Constitution of the Republic of Indonesia, which states that the state of Indonesia is a state of law. Therefore, human rights shall be upheld in accordance with the principle of a democratic and law-based state. In the criminal system in Indonesia, life imprisonment is part of the main crime in the types of crime as regulated in Article 10 of the Criminal Code. A life imprisonment can be given in many criminal cases such as drug trafficking, corruption, even terrorism. It is a basic assumption that imprisonment has a strong deterrent impact. However, the issues that have arisen as a result of imprisonment-focused criminal law enforcement have resulted in several issues that undermine the aims of the criminal punishment, where in line with the concept of the penitentiary, the goal of punishment in 2005 Draft Criminal Code is to socialize the convict through counseling so that the people becomes a good and tolerable person. Admittedly, an inmate at the penal institution is a human being who needs to be recognized for his or her human rights as a whole person. However, there are a number of issues that arise when it comes to fulfill that prisoners' basic rights are upheld, including the first one is overcapacity. Based on the data from Directorate General of Correction, the number of prisoners and detainees in Indonesia as of April 11, 2020 has reached about 225,000 people, while the total prison capacity is only for 132,000 inmates and detainees. Meanwhile, according to the World Prison Brief data, prisons in Indonesia overcapacity by 104%. This happened in several prisons in Indonesia, including at the Class 2A Correctional Institution in Magelang, where the capacity of the room is for 221 people, but it is filled by more than 500 people. In Cipinang, Class 1 prison that with 3,000 people, that show the capacity having for 800%. And then in Palembang prison was occupied by about 1,000 with a capacity of about 500 people. This is because the large percentage of use of prisons in legislation and imposition of imprisonment are not balanced with the sufficient facilities and infrastructure. As a result, there have been a number of cases of inmates committing various violations, such as convict escaping, prison riots, drug distribution, control from jail, illegal levies taken by prison authorities, and a variety of other issues are only some of the issues that have arisen. One recent example is the fire that happened in the Class 1 prison in Tangerang in September, which claimed that the lives of 41 inmates. This is due to overcapacity in prison of up to 400%. And then the second is understaffing. Furthermore, understaffing has long been a problem in correctional facilities around the country, with only 800 guards overseeing more than 18,000 convicts in Jakarta. Bali and North Sumatra have 300 and 1,000 guards respectively, significantly less than the number of detainees imprisoned in the two provinces. And then the third is lack of facilities. Furthermore, the lack of facilities as seen is Salemba Penitentiary in Jakarta, where a room filled by the several dozen convicts and a narrow corridor further stocked with prisoners lying next to each other. There were only 2 lavatories in the hall, water and thrice a day in 2 shower and 4 taps. Even inmates had to fight over who was going to take shower next. As a result, the lack of the maintenance such as equipment distribution, eating, dressing, drinking, bathing, and sleeping not being carried out on the regular basis due to limited funds, which must be allocated to all needed prisons in terms of administration, coaching, and treatment of correctional inmates whose number exceed the capacity. Moreover, we'll have a very fast effect on prisoners and prisoners contracting infectious disease, especially during this pandemic era. And then about the underfunding, especially in the pandemic era, as of March 2020, the country had about 270,000 inmates, according to data cited by the Human Rights Watch, which said that the estimate was more than double system's capacity. As a result, all prison operational resources have been diverted to simply accommodate the growing number of inmates, resulting in insufficient resources for vital services such as the rehabilitation program. In fact, this also resulted in maintenance such as distribution of equipment, eating, dressing, drinking, and so on, were not carried out routinely due to limited funds. And then about the lack of mental health service, that convicts which oftentimes are placed in overcrowded facilities with inadequate clothing and food and vulnerable to disease without sufficiently accessible healthcare, including access to medical testing as well as medication to treat conditions, are often difficult to obtain, especially for mental health conditions. Given that the results show that the life imprisonment sentence had high level of depression, and the adverse effect of the prison sentence are aggravated by obstacles in returning lifelong prisoners in the community, as a small possibility of life imprisonment sentences to obtain remission. And then about the access to get a special coaching. The lack of staff and the overcapacity of prisoners resulted in the implementation of coaching and mentoring for prisoners not being maximal. For example, in Makassar Class 1 Penitentiary, where in July 2021, there were about more than 1,000 inmates, this data show that there was an overcapacity of 26%. Meanwhile, the number of employees in 2001 was recorded as only 145 active employees. The data show that the number of residents in prison is 7 times more than the number of existing employees. Furthermore, there is no specific training. Lifelong convicts get the same guidance as other inmates. This is clearly in violation of Article 12 of the Government Regulation number 31 of 1999 on correctional inmate guidance and guidance, which states that if it is not possible for prisoners to get opportunity for assimilation or integration, the prisoner concerned are given special guidance, given that the life imprisonment doesn't allow for assimilation opportunities. And about the next will be explained by my partner.
Regarding access to get remission, although prisoners have the right to obtain remission from life imprisonment to temporary imprisonment as regulated in law number 12 of 1995 concerning correction, government regulation of the Republic of Indonesia number 32 of 1999 concerning the term and procedure for the implementation of the right of prisoner in prison. and regulated further by the Presidential Decree number 174 concerning remission, which states that prisoners will be granted remission if they adhere to the coaching program and don't violate the rules. However, there is no daily report on the development of attitude and behavior of lifelong inmates in several prisons. Despite the fact that report on the development of attitude and behavior of lifelong prisoners are required by community counselors because they will be used as a source of data which can then be used as basis for assessment in granting remission. As happened in the Makassar Penitentiary, which essentially didn't carry out its function properly. There is no writing daily report on the attitude and behavior of prisoners, so there is no standard that can be used to determine whether prisoners' behavior has changed or not. And then regarding human rights fulfillment, in general, it can be explained that it is based on the Constitution, namely Article 28G, Paragraph 1 of the 1945 Constitution, which essentially state that every citizen has the right to be protected by the state, including those with the status of prisoners, or the right for inmates in prison are regulated by law number 12 of 1995 concerning correction. However, the problem that arises and need to be highlighted are imposition of life imprisonment for prisoners, whether it's relevant to be principle of rehabilitation and resocialization, which are the basic principle of correctional institution. This is because the convicts who are serving life sentence will have difficulty returning to society and establishing a resocialization process because prisoners sentenced to life imprisonment must remain in prison as long as they don't get remission. Moreover, the lack of facilities.
2 minutes, thank you. 2 minutes left, thank you.
That causes poor sanitation condition will accelerate unhealthy environmental process. This is contrary to the government policy in providing health service to the people who are in correctional facilities and state detention center. And then regarding recommendation, the achievement of the purpose of punishment by a criminal must be able to accommodate all aspects of protection which are essential of the purpose of punishment, such as the socialization process and human rights fulfillment for prisoners. Life inmates can get their right to get remission of criminal charge from life imprisonment to temporary punishment. To support this, funds and facilities for coaching need to be improved so that reintegration process in the correctional system can run optimally. Regarding the overcapacity, alternative solution in overcoming that occurrence of overcapacity in correctional institution by applying criminal sanction against perpetrators in the form of criminal sanction are not only aimed at the penal sanction, but can also be applied at the criminal sanction such as non-reasoning, criminal supervision, criminal penalties, criminal social work, and parole program are examples how diversion and restorative justice concept can be applied while maintaining basic human rights. As a result, the problem of overcrowding at the penitentiary institution will be addressed and the criminal process will continue as planned. Thank you.
Thank you so much for your interesting reflections. We'll need to add both of your names to the program, but thank you both for your input. We now have our 6th and final presentation of the conference, and we have 5 authors on this paper who are all based at Batangas State University in the Philippines. We have Dr. Jennifer Manalo Cueto, Dr. Jessie Nelson P. Lana, Associate Professor Sandy M. Gonzalez, Assistant Professor Novilette C. Molo, and Mrs. Elaine Noreen G. Baxter. And I look forward to hearing your paper very much. Thank you.
So good afternoon to each and everyone. I am Mrs. Elaine Noringa Chilian Baxter from Batangas State University, Philippines. I'm one of the authors of the research study. So I would like to acknowledge, of course, the other authors of our research study who are also joining and participating in this online conference, Dr. Jennifer M. Cueto, Assistant Professor Lovelet C. Molo, Associate Professor Sandy M. Gonzalez, and Dr. Jessie Nelson Piliana. All right, so we have here Batangas State University Lemery campus. It's actually Lemery, Batangas, Philippines. So it's the 2nd smallest campus in the university. So our study is applicability of special laws in the Philippines punishable by life imprisonment. So life imprisonment is one of the issues that are crucial and controversial to discuss. So in the Philippines, the penalty of life imprisonment is provided, which is called as special laws. So to clearly understand these special laws, a wide overview of Philippine law should be understood. So Philippine law can be classified into 3. This includes substantive law, procedural law, and administrative law. So substantive laws are the revised penal code, civil law, labor code, and taxation law. Procedural law, on the other hand, is the rules of court embodied in the civil procedure, criminal procedure, and special proceedings. However, administrative law is a branch of public law that is concerned with the procedures, rules, and regulation of a number of governmental agencies. Administrative law specifically deals with such administrative agencies' decision-making capabilities as they carry out laws passed by legislative acts of Congress. An example of administrative law is the regulation and operation of the Social Security Administration and administration of benefits to the people. Special laws having a penalty of life imprisonment emanates from substantive law. So this has been emanated in the form of legislative acts of Congress. So these special laws are enabling laws to give furthermore teeth to substantive law. So this operates to the widen the scope of provisions in terms of commission of a certain crime and furtherly elaborate matters pertaining thereto. So according to Aquino 2017, special laws are applicable in the Philippines according to the commission of an offense. The penalty of an offense charged under the special laws is life imprisonment. So our paper focused on life imprisonment and reclusion perpetua. Presidential Decree 269, August 6, 1973, which is the National Electronification Administration Decree under Section 54. The Philippine Red Cross Act of 2009, enacted on April 20, 2010 under Section 10. And the crimes punishable by life imprisonment includes number 1, Republic Act number 7877, which is an act declaring sexual harassment unlawful in the employment, education, or training environment and other purposes. And the second one is the Republic Act 11313, which is the Safe Places Act, an act defining gender-based sexual harassment in streets, public spaces, online, workplaces, and educational or training institutions, providing protective measures and prescribing penalties. So for the objectives of our study, number 1, we would like to ascertain the difference between life imprisonment and reclusion perpetua in the Philippines. Secondly is to determine the Philippine crimes punishable by life imprisonment. And lastly is to discern the applicability of special laws in the imposition of life imprisonment in the Philippines. So for the method, so this is a qualitative research through content analysis, and the basis of our discussions mainly comes from the laws in application to life imprisonment. Okay, so I would like to invite Dr. Jessie Nelson Liana to discuss the results and discussion of our research study. Doc Liana.
Good afternoon, everyone. Good day, everyone. I will discuss about the results and discussion. Life imprisonment and reclusion perpetua. In the interview conducted by Rubilios in 2015 of CNN Philippines to attorney Theodore Te, he explained that the life imprisonment and reclusion perpetua are distinct and separate penalties with different natures, periods, and consequences, meaning it can't be used interchangeably. The legal consultant mentioned that reclusion perpetua is a penalty for a crime committed under the revised penal code, while life imprisonment is a sentence for a crime that falls under a special penal law. Under Administrative Circular number 6-A-92, 1993, signed by Chief Justice Andres Narbasa of the Philippine Supreme Court, he emphasized that reclusion perpetua is not the same as life imprisonment. The fact that does not have an accessory penalty and do not have any definite duration or extent. Crimes punishable by life imprisonment, Republic Act number 7877, an act declaring sexual harassment unlawful to employment, education, or training environment, and for other purposes. This requires the employer or the head of the work-related educational or training environment or institution to establish procedures for the resolution, settlement, or prosecution of sexual harassment incidents. The employer must form a committee on decorum and the investigation of sexual harassment cases. Section 7, the penalty. The penalties. Any person who violates the provisions of this act shall upon conviction be penalized by imprisonment of not less than 1 month nor more than 6 months, or a fine of not less than 10,000 pesos nor more than 20,000 pesos, or both such fine and imprisonment at the discretion of the court. Any action arising from the violation of the provisions of this act shall prescribe in 3 years. Republic Act 11313, Safe Spaces Act. This is an act defining gender-based sexual harassment in streets, public spaces, online workplaces, and educational or training institutions, providing protective measures and prescribing penalties. The Safe Spaces Act defines gender-based sexual harassment in public places, on the internet, in the workplace, and educational and training institutions. The law criminalizes all forms of sexual harassment in public places.
Dr. Lana, you have 2 minutes. Thank you.
Okay, so Section 14, the penalty of prison correctional, medium period for a fine of not less than 1,000 pesos, but not more than 500,000 pesos, or both, discretion upon the discretion of the court, shall be imposed upon any found guilty of any gender-based on sexual harassment. These are the special laws punishable by life imprisonment. Presidential Decree 269, August 6, 1973 is the National Electrification Administration Decree. This is creating the National Electrification Administration as a corporation, prescribing its powers and activities, apportioning the necessary funds, therefore, and deciding a national policy objective for the total electrification of the Philippines on an area coverage service basis. This law is a special law with the emphasis on the penalty of life imprisonment in case of violation or any circumvention of this law. Another is an act recognizing the Philippine National Red Cross. That is also an example of special law. And for our conclusions, the penalty clause for Presidential Decree 269, otherwise known as the Electrification Code, the National Electrification Administration Decree, is provided under Section 54 for the Philippine Red Cross Act. The penalty clause is under Section 10. So this penalty or those penalty deals with life imprisonment under the special laws provided herein. Unlike penalties under the revised penal code, that there are a graduation of penalties. The penalty of life imprisonment is at the one specific duration of period. Life imprisonment should not be taken in the literal sense. It has still be imposed on the exact penalty provided under the special law. So the crimes punishable by life imprisonment.
Dr. Lanas, I'm sorry, we need to move to questions, but thank you very much. Okay.
Thank you, ma'am.
We have approximately 15 minutes or 10 minutes really for discussion. Unfortunately, my mouse in the 11th hour has stopped working, and I can't, even though I have a touchpad screen, I can't access the chat or scroll down through the chat. So I've called on my colleague, my good colleague, Dirk, who's going to help read out the questions, and we'll respond to them accordingly. Thanks, Dirk.
The first question for Indonesia, I think, had to do with the percentage of death row inmates. Is that the one you had in mind? In Indonesia, what percentage of death row inmates whose sentences are reduced to life in prison by presidential pardon. Is this truly considered a hope for death row inmates? Is there any research on why it's more difficult to get a pardon? Now, there is a written reply to that. I think the question was still from the previous session addressed to Go. But I think this is a very interesting question, because what we know is that imprisonment for life is not always imposed by the court. Very, very often it comes in countries which have the death penalty from commutation. So if one of our Indonesian speakers wants to address that, either Go or the two colleagues who were speaking later, that would be very helpful.
Yeah. Thank you, Professor Dick, and also Dr. Catherine Appleton. I have already written in the chat box to reply Mr. Doug, but I would like to reply to the response of the question. Actually, I'm sorry, I don't have the data in exactly about the percentage of death row inmates. But I have tried also to Googling from the ICGR, but I only find the number of the death penalty that has been imposed by our by the Supreme Court. There are cases punished to the death penalty according to the ICGR, International Criminal for Justice Reform in 2020, based on our Ministry of Human Rights data in 2020. There are 355 cases, which included in 2020, but the explanation about but I would like to try to explain from the mechanism, because like giving emphasis to the question of Mr. Nguyen Quang Duc. Actually, the process of presidential pardon in Indonesia is not easy also. We have to collect, the president must have the advice from the Supreme Court first before they decide whether president will give the presidential pardon or not. So after they have 10 years of waiting for the time before the execution of the death penalty, the head of the prison must apply to the minister to ask the president to give consent to this accused with the death penalty, and after that, by consideration, the president will give that whether he wants to give president want to give with pardon or not. That's the process in Indonesia. So I can mention here whether it is not whether it can be truly considered as a hope for the death row inmates. I'm not yet sure how to consider, but as long as I understand, our system also is trying to give the less sanction, to apply what is something that beneficial to the offender. In my opinion, because I learn about criminal law, so it is that I can say whether this can be considered as a truly consideration or not. But I can say that our law actually wish to give the less sanction to everyone who has been the offender. That's my question. That's my answer, Professor Dick. Thank you.
Thank you very much, Go, and thank you, Dirk. I understand from Dirk there are no further questions or comments for this session. Is that correct?
Yes.
In which case, I will move on swiftly and in good time, in fact, slightly early, to our final general discussion. So this is where everyone can participate. So we're moving away from presentations and towards the closing remarks, but we have some times where we can all contribute to this final discussion. I have to say it's quite sad that we're coming to an end of this pioneering event. I say pioneering because it really is the very first time the issue of life imprisonment in Asia has been presented and debated globally. And I can't tell you how incredibly honored I am to be part of it. I know Dirk as well. would say the same, but also actually quite moved that it's happening now. As Dirk mentioned when we started, we've been looking at this issue for cumulatively 50 years together. And it's taking a lot of time to put the issue of life imprisonment on the agenda of human rights. The death penalty has dominated that agenda, and perhaps rightly so. But now life imprisonment and what we should do with those who commit the most serious crimes has come to the fore. So this event is really a huge achievement as I see it. And I'm sure from this we're going to have many other opportunities for future events where we can meet together again. And thankfully, one of the positives of COVID means that it's possible, it's doable. I saw yesterday, I think we had at one point over 200 participants here. And I actually think that might not be possible other than through Zoom and the possibilities that have arisen from the pandemic. But before I open the floor for discussion, just a few words of thanks really from myself and from Dirk at the University of Nottingham. These events inevitably involve a large amount of organisation behind the scenes. So in that respect, I would firstly like to thank Associate Professor Jiao Hu Kong and his colleagues for firstly initiating this event, sending us that email to say, do we think it would be a good idea? And approaching us to take things forward with them. Also for bringing together such a large group of people from Asia and beyond to focus on this topic of life imprisonment. I also want to thank Sarah Biddle at the Asian Law Centre at Melbourne Law School who opened the event for us, and particularly Catherine Taylor for the way she has administered the whole build-up, the production and the process of this event. It's hugely impressive. Thank you, Catherine. Behind the scenes, I know, but without your help, we couldn't be here. And talking about behind the scenes, I really want to thank our translators who worked tirelessly yesterday and today. Your role is absolutely crucial in facilitating a shared understanding of this topic, and that in turn is crucial for making progress and reform in this field. So thank you as well. And also, of course, we're very grateful to our speakers and our discussants. Thank you for your papers, but also thank you for getting up incredibly early or staying up very late, working. I think yesterday I saw that our Canadian colleague was up at 5 in the morning, he said. It's impressive and it shows commitment and passion for this field. I'm going to speak a bit more about the publication plans at the end of our discussion, but we've got probably about 20 minutes or so to bring together final thoughts, queries, comments, questions. Because my mouse is not working and I can't see the chat box, please could you raise your hand and hopefully I will be able to invite you to come to the floor and give yourself 3 minutes or so to either just comment or simply introduce yourselves. Feel free to say what you're doing in this field and that you'd like to stay in touch and so on, or whatever comments you have about the event that we've had. So let's move to that. I'll try and see you all.
Could I just add entirely practically, in order to raise your hand, you need to click on reactions at the bottom, and then you'll see a little hand and that will enable you to move it up.
Thank you, Dirk.
Now I've showed you how to raise a hand. You should see it on the left of my picture. I see there's one from Dr. Jesse Nelson as well. I'll step back to him and follow him.
Thanks, Dr. Jesse Nelson.
We would like to give our deepest thanks and appreciation by making this opportunity for us from the Philippines, from our university, Batangas State University, Lemery campus. We are so very much appreciative, and we deeply appreciate your giving us this great opportunity to share our laws in the Philippines, as well as the implementation of the penalty of life imprisonment. So hope to see you again in the next succeeding event like this, conference like this. So we extend our deepest appreciation, and we are very grateful to be part of this conference. Thank you, and stay safe. And we really appreciate this. Thank you so much.
Thank you, Dr. Rana. I can see some applause as well. Okay, Dirk, you have your hand raised.
Thank you, Catherine. I want to join in the thanks, and I particularly also want to thank our Vietnamese colleagues. I think that much of the technical stuff has been done from there, and I particularly want to thank Xiao, who's been absolutely marvelous in the long presentations for these things. But before we spend our time mutually congratulating each other, I do just want to reflect on what I've learned from this. I personally found this a wonderful experience. Most of my experience in Asia has been in Malaysia, although I have visited some of these other countries, and I really felt I learned a lot. I was deeply impressed by the way in which people looked not only at the law, but also what happens to people in life imprisonment. And I think that's very important, and I hope we will get more research of that kind. The one thing I want to underline is the importance of empirical information. One of the difficulties in this area in Asia is something we've really skirted over a bit, and that is that in some countries we don't have statistical information. I think the information, I was listening to Tepe's paper and the earlier paper yesterday on Japan, and they stood out as examples of the sort of empirical information that's important. And why I emphasize this is to make a purely scientific point. We speak about different release systems, and there seems to be a consensus amongst this group that while we're not close to even thinking about abolishing life imprisonment, we are close to thinking about not having life without parole, not having life that you can't be released from. And we've had some fascinating discussions about release systems, and I appreciate that. But the only way to judge a release system is to see how many people are actually released. You may sketch a beautiful system, but in practice, no one's ever released. And this underlines the problem with life imprisonment. The biggest problem with life imprisonment, I believe, if you look around the world, are forgotten people. Someone can be sentenced to life imprisonment, and if there's no statistic, no information on release, that person can be kept by the state forever. Now, there may be some people that are so dangerous, we need to keep them for very, very many years. There may be some people who are so evil, we have to keep them for a long time. But we need to know, because if we don't, they can simply be left behind. So I really urge my scientific colleagues in your various countries, please say to your governments, as I've tried to say to them when I've visited countries, it's not a shame to have a system of life imprisonment. Most countries in the world have one, but don't hide the information. If you give us the information, we can give you our best objective opinion on whether the system would work, whether it doesn't work, whether it's fair or it's not. So if I can make one plea, together with all my thanks, because I think we are moving forward very much, it would be to emphasize that aspect. Thank you.
Thank you, Derek. Do we have any further hands?
Sorry, I thought I saw Tepe's hand a minute when I started.
Oh, sorry, Tepe. Please take the floor.
I didn't raise my hand, but thank you very much for coordinating this wonderful conference. And without such an opportunity, I didn't know what is happening in Asia countries, especially in relation to the life imprisonments. Thank you very much. And if we have another opportunity to meet in person, that will be very fine. And I definitely join there in the future. Thank you very much.
Thank you, Kathy. And Farah, you've got your hand raised over there.
I did. Hello. Thank you, Catherine, for this opportunity. May I just ask Catherine and you and Dirk, what will the next step forward be, at an Asian level? I think I heard something about this inputting, what we have presented in this conference into something more tangible as an output. That's one. The other one is that I think I've mentioned in my presentation yesterday that I'm probably where you were with the many years ago, that is, there's hardly any information on life imprisonment in Malaysia, and I had difficulty starting when you requested a paper out of me. And I have written to the prison department for data, because as you know, in many ASEAN countries, that can be very difficult, because you need to prove that, you're conducting a cogent research and all that, because otherwise, all this will be termed as, classified data, and it's really not easy. But yes, I agree that we need to know how many. And although I have said yesterday that it's only in very limited offences that imprisonment for natural life, but what I'm more concerned is the 30 years imprisonment for, the other category of offences, which is really very long, and many would have died before reaching that 30 years maximum. Thank you very much.
Thank you, Barry. The points you raise are really important. Just to address them in reverse order. The problem with data is a crucial one. Data not only matters, as Dirk says, because we will have forgotten people without it, but also data matters because what we found when we go to our colleagues at the UN level, that they want to know the statistics, and the statistics make noise. They quote the statistics as to put forward this cause onto their agenda. So it's actually a way of really making change. And we will emphasize, and we have emphasized in our previous book, and we're currently trying to do a second sweep, as many of you know here, of data collection globally. And we are so grateful for the information that we receive. But in some countries, it really is impossible. And that should be, I think, also on the UN agenda, to get data readily available and publicly available on this population. In the same way that death penalty advocates have pushed for death penalty data. Moving on to outputs, Farah, as you mentioned. So I mentioned we had some solid publication plans earlier. We have two strands, essentially. One is for an immediate publication of the conference papers that we've all heard. And I know that Dr. Maritis Olea from the International Organization of Education and Researchers, I think IOER, if I'm right, will be able to say more about this in the closing remarks afterwards. But the plan essentially is to publish the conference proceedings, certainly as I understand it, in their International Multidisciplinary Research Journal online and open access. So that will hopefully be available in the near future as we work together for that. The second longer term strand that we're trying to work towards is publishing an edited book collection with a publisher such as Palgrave Macmillan. We're planning to approach them with selected papers from the conference. So we'll see how that goes. I think there should be a lot of interest in that as an output from globally, and I certainly think it's one that we will be keen to pursue. So we're just making inquiries, and we'll see if it's possible and keep attendees listed. So that's where we're at with outputs so far. I hope that answers your question. John, great to see you. I'm not sure what time it is there in Australia, but the floor is yours.
Thank you, Catherine. Yes, it's getting about 8:30, I think. Thank you. I just wanted to thank the organisers as well, and it was very interesting for us from my perspective to hear what's life imprisonment in Asia. I think one of the important takeaways for me also is the importance of it being an international effort, and that we, the data collection is significant. And I know, having collected data here in Australia, that it can be sometimes frustrating to particularly drill down into the data and to find things even in a country that, supposed to be open with their data and their systems and so on. But I think for me, international cooperation and benchmarks and the human rights aspects have been very important themes in the conference and have come through to show that, you know, together I think we can make a better effort at raising the profile, and this has been a great step forward in that direction. So thank you.
Thanks, John. I've just sent a message via Skype to Dirk to see if he would just put a link to our research site so you can see what we're trying to do with the global study. And there we have a list of acknowledgements of people who've helped us from various countries. We would be delighted to hear from you. We hope to get data on every single country in the world, but we do have to make guesstimates or estimates. And when we did our first study, we predicted that there would be over 500,000 licensed prisoners worldwide in 2020. And what we'd like to do is see if that prediction was anywhere close to being true. We think it's an underestimate, and particularly we think it's an underestimate because, well, we've mainly been focusing on what Dirk highlighted in our presentation on formal life sentences, those where the court announces that you are sentenced formally to life imprisonment. There are a lot of sentences like de facto life and indefinite preventive detention, which we call informal life. And that is a very difficult number to find out. But we're doing, with the help with one of a law company, an international law company, DLA Piper, we are trying to scrape the surface on that this time around as well. But please do go to our site for more information on that. Thank you. We have another colleague who's got their hand up. Please take the floor. I think it's Mr. Gonzalez.
Yes, good afternoon from the Philippines. First and foremost, I would like to thank the organizer of this activity for giving us this opportunity of sharing with the world the research study that we had conducted. And based on this conference, we learned so many things, most especially with regards to the practices of different countries in relation to life imprisonment. And based on the sharing that had been given by everyone, and we have seen the best practices of different countries in relation to the topic. And with these learnings, and we can further enhance the different studies that we are now conducting in our university, and hopefully we will be able to share with others once again if there will be another conference like this that will be organized. So thank you very much to all of you, and stay safe, everyone.
Thank you so much. That's really helpful. Is anyone else itching to put their hand up? Please just feel free. Okay, well, before I hand over the floor, I think I can see Dirk there. He's now put our website on the chat. But before I hand over the floor to Jiao for the closing address, I would just summarize really to say that I think what's bonded the papers and the theme that runs throughout the conferences is around the world is this awareness and concern of a global need for life imprisonment reform. So one thing is to direct you to the work that we're doing, the study that we're doing to try and move in this direction. But also, I wanted to let you know that Penal Reform International are trying to form a world coalition on life imprisonment reform, or reforming life imprisonment around the world. It's still work in progress, but because we're sort of seeking funding with them to try and make something of it. And I know some of you are already members of that and contributed to an event there, but there will be an event that they're organizing later this year to try and, like this event, bring people globally together to talk about the issue of the kind of global human rights crisis, as it were, in relation to life imprisonment. So if you're interested in joining or hearing more about that, contact us, but also look at the Penal Reform International website. There's some more information there, and I think Dirk might add their website to the chat. It'd be great to have your participation in that too, as a network. So finally, just a very big thanks to everybody again, particularly to our organizers and our great colleagues in Melbourne and in Vietnam. And now I'm going to leave you in the good hands of Associate Professor Jiao Wukong. But I understand that first, Dr. Marites is going to talk a little bit more about our immediate publishing plans. So thank you so much, and please do stay safe, everyone. Bye-bye.
Okay, so hello everyone. Good afternoon from the Philippines. Okay, so thank you, honorable guests, paper presenters, and participants around the globe for your enthusiastic participation in the 2 days online conference about life imprisonment in Asia, law and practice, organized by Melbourne Law School, Vietnam National University Hanoi, Nottingham University, and International Organization of Educators and Researchers Incorporated. So thank you, paper presenters around the globe, for your informative and excellent presentation and the fruitful discussions. So we learned a lot from you. So the wisdom you shared in this session might help to create a foundation for quality law and practice of every nation. So thank you everyone involved in this planning and holding this event. We are truly grateful for your valuable contribution for the success of this 2 days conference. And in behalf of International Organization of Educators and Researchers Incorporated, I would like to take this opportunity to humbly thank the Melbourne Law School with Academic Convenor, Professor Sarah Bidup, Manager, Ms. Catherine Taylor, the Vietnam National University Hanoi with Academic Convenors, Associate Professor Bu Kong Giao, and Dr. Li Lan Shi, Administrator Dr. Mai Van Tang and Dr. Bu Chen Dat, Assistants Mei Van Tang and Nguyen Jun Giang, Nim Min Giang and Pi Huyen Truong. And also to the Nottingham University with Academic Convenors, Professor Dick Van Zyl Smith and Dr. Catherine Appleton, Administrator Marie Ote. So thank you for the opportunity to collaborate to this prestigious event. So thank you everyone and have a blessed day. So thank you. Back to you, Dr. Giao.
Good afternoon, everybody. I am very honored to deliver the closing remark on behalf of Associate Professor Nguyễn Thị Quế Anh, Dean of our VNU School of Law. Firstly, I said the evaluation of the conference of the Professor Van Zyl Smith and Dr. Catherine. We believe that our 2-day conference have produced very good results. With 7 sessions and more than 20 papers presented, we enjoy a lot of very insightful discussion between the participant and speaker. Thereby, I think we can gain a lot of knowledge and information about an issue that I think is still rather new in many countries, including Vietnam, our country, which is the life imprisonment. The success of the conference, from my observation, was achieved thanks to the contribution from all of you. We would like to express our sincere thanks to all of you, the speaker, the moderator, the participant of the conference. And we would also like to say thanks to the 2 translators and the technical staff of the Melbourne Law School and the VNU School of Law. In particular, we would like to say thank you very much to Professor Dirk Van Zyl Smith, Dr. Catherine Appleton from the University Nottingham School of Law, Professor Sarah Bidup and Mrs. Catherine Taylor from the Asian Law Center, Melbourne Law School, and Dr. Maritet Dole, President of IOER, for the cooperation with us in preparing for the conference over the past few months. We admire your profound knowledge and professionalism and dedication. We look forward to continue academic cooperation with you all in the future. Before concluding our remarks, with permission from the conference co-organizer, we are pleased to inform the author that we have a plan to publish the conference paper, as Dr. Catherine said earlier, in 2 publications. The first is a monograph book tentatively published by Macmillan publisher in UK, and a special edition of the IOER journal. This will probably take several months after the end of this conference, and we will contact and consult the author for that for the permission in preparing for the publication. And now it is time for me to say the last word to close our conference. We wish you all stay safe, happily, and success. We look forward to seeing you again in our future conference. Once again, thank you very much and goodbye to you all. Thank you and goodbye.